Your Honor, I am from Bhadrak through virtual High Court. Virtual. Matter of this.
Yes, you are Mr. Nayak.
Yes, sir.
Okay, all right. Yes, Argu, what is your case?
The matter of this case, Your Honor, the transfer by the OP. Number 2.
You challenge Annexure 5?
Order of collector Bhadrak.
Right. Where is the certified copy of Annexure 5?
Yes, sir. I have filed the certified copy of order of collector 7/10/23.
No, where is the certified copy of Annexure 5?
Available in record, sir. Available in record.
Pardon?
Available in record, Your Honor.
I don't find here.
It is virtual High Court, virtual court, Your Honor. Copy is available here.
You are saying won't do unless I get that. Find out if it is in your file.
The order
Order
annexure
dated
7/10.
7/10/22.
Yes, sir. Yes, sir. 32 to 35 page. Annexure 5.
Yes, Annexure 5 is 7/10/22.
Sir.
So where is the certified copy? Unless you give certified copy, matter is not regularized.
Sir, record is available here. Please go through the visual.
Do you propose to file?
I have filed on it, sir.
Oh, then I am dismissing. I don't find here.
No, sir. It is actually. Please go through visual. Now, visual. Visualizer. Please go through visualizer.
Eight question involve a challenge to
Copy see auction. See auction copy. Copy see auction.
pardon?
Copy ku see auction.
Copy share auction come for so coach mu file kar sakti bole. And I am giving him opportunity, he is not inclining. Who can help him? Doesn't understand unless the certified copy is there. It's not a suit. Even suit also exhibits had to be certified copy.
Yes.
Sir, please the copy go through visualizer.
Your holding will not satisfy me. Why are you holding it with you? If you challenge that order.
Sir,
What do you want now? What do you want now?
Order of collector. I must submit.
The voice is not visible, audible. कौन कहते हैं आप कौन चाहते नहीं सर्टिफाइड कॉपी डिसमिस कर देबी
ମୁଁ already ଦାଖଲ କରିଛି ଏଟା ଭର୍ଚୁଆଲ କୋର୍ସ ଆମେ ଏଇଠି ଦାଖଲ କରୁଛୁ ଭଦ୍ରକରେ ତେଣୁ ଏଟା ସାର୍ ସ୍କାନ ହେଇକି ସାର୍ ଯାଇଛି ତେଣୁ କରି ଏଠି କପି अवेलेबल ସାର୍ ଅଛି ମୁଁ already ଫାଇଲ କରିଛି ସାର୍
all right ask the person attending that office to be on board अरे बाबू जी सेठी आपन को आशीष करछन्ती ताको कोंतु आगु को आसीबाकू हां सर्टिफाइड कॉपीटा सेठी अछि Annexure 5 रो you are sure all right ना ताको रेकॉर्ड रे अछि
नहीं सर
okay all right it is there
सर
okay even though there is no attachment of the certified copy of Annexure 5 here, but however, the person attending VC hearing placed at Bhadrak ensures of having the certified copy of Annexure 5 in the brief submitted to him for the purpose of registration of the case in High Court. Since this is a filing of writ application in the VC center, defection and ignore. Yes, what is your submission on merit?
Sir, the collector Bhadrak has filed
The 34/35. This is disposal under 35.
35 years, Your Honor.
Private parties are there.
Private party, yes, sir.
Take notice. issue notice on the question of admission.
Sir.
Fixing short reasonable date, notice accordingly करेंगे.
Sir, just injection.
You have a mistake.
Yes, sir.
Till the final proceeding. There shall be study with regard to possession of the land involved herein to be maintained by the party in possession of such land. Yes, yes, I have granted stay, status quo order rather. The VC order hearing going.
Item 2, my lord. It's a covered matter, my lord.
Covered ହେଲେ copy ଦଉଛନ୍ତି
Copy
ଦେଇଛନ୍ତି।
annex
ତାଙ୍କୁ ଦିଅନ୍ତୁ।
annex ତ ରୋଡା ବି ଦେଇନାହାନ୍ତି annex ତ ରୋଡା ବି ଦେଇନାହାନ୍ତି
ପୁରୁଣା ରେଟ୍ ର ଅଛି ମାନେ I have amended the
ସେ
ନାଇଁ amend କରିକି ନା କରିଦେଇଛି
ଦିଅନ୍ତୁ ଆଉ ଗୋଟେ copy ଦେଇ ଦିଅନ୍ତୁ।
sir sir
এটা covered ହେଲେ ଏଟା this needs a judgment.
15B order ଟା challenge ହେଇଛି
So you examine if it is covered. Mr. Panda.
my lord, my lord.
and
you
old
examine
settlement
if it is covered by this judgment. I am calling it next Friday.
Yes,
Means petitioner seeks coverage of the order. A coverage of the proceeding with the judgment of this court in WPC 5042 of 19 read with WPC 9426 of 23 delivered on 13/4/23. Get ready, there is wrong decision of the collector. So, there need not be reference of the matter to the RDC.
next Friday.
Yes, the matter next Friday. Next Friday,
Your lordship may call Thursday, my lord.
Thursday. Thursday.
Item 3,
May I please, sir? Here is the case, the opposite party number 7 fraudulently taken about the opposite party number 7, namely Vijay Mahanti, who has fraudulently taken the Aadhaar and voter ID card by changing the name of the name of his father.
What is your complaint in the representation?
My lord. In the representation, I have made to the opposite party number 2 and 3 to cancel the Aadhaar card and voter ID card, my lord. In pursuance, my representation to the
Then what the
Yes,
collector will do in such
Yes, sir.
matters?
initial aspect 45-42, my lord, 7, I have represented the
No, there can't be adjudication by collector. You allege fraud.
my lord.
You allege fraud. What the collector will do?
Because of my lord, the
Sorry,
pursuant-
go to civil court, get a declaration.
my lord, in this case, my lord, I am only checking your lordship
Collector cannot enter into such controversy.
upon the direction of the my lord.
Fraud has to be established. It's only allegation.
Inquiry has been made, my lord. In this case, as per
Forget
Annexure
about,
7,
forget about any
inquiry has been
inquiry.
made.
There can't be any inquiry. It is either entering into a criminal.
also inquiry already made, my lord. In this case, page 45, my lord, is a case.
Hmm.
It's found that there is an illegality.
Page 45.
Yes, ma'am. Page 45. The inquiry report start from
Page
44, my lord.
44.
Start-
44.
Inquiry report
44
start.
is a request,
No, no, ma'am.
is a report.
Yes. Yes, that is the inquiry report. Where is the relevant is page 45.
So institute a criminal case. What the collector will do now?
And subsequently, my lord, after this incident, the collector has cancelled the NG NG NREGS card and the can withdraw the
There
Kaliya
is
Chaudhary.
involvement of question of adoption, whether that father was issueless or not, all these things are there. They have to be established in a court of law.
Well, here is the
No
case.
inquiry can
I-
complete such
I'm
proceedings.
only taking only 2 minutes, my lord. Here is the case, my lord. Kindly see the genealogy here, this at page 5, my lord. I've stated so, at paragraph 3, it is that genealogy. Here is the Shatrughan Mahathir's dad.
What benefit he is drawing?
My lord, here is the case, my lord, Ramachandra, in the family of Ramachandra. Shatrughan has 3 sons.
What benefit he is enjoying?
He is treating himself the son of Ramachandra.
Oh, what benefit thereby he is taking?
Everything, my lord, by getting the Aadhaar
So
card.
if he is claiming, then how are you affected?
But I am, petitioner is the nephew. There is no issue and
So go to civil court, get an adjudication of the issue.
whenever at the case, if the Aadhaar card and voter ID,
Sorry.
let the collector or actually
No,
consider my repayment.
No, sorry. It's a serious question. Whether he is son or not, adopted son or not, and you have a right over this property or not, all these things have to be adjudicated in competent court.
That has been
Not by
depended
the
in court.
public
That
officer.
has been depended. He has not produced any adopted document. He has not
At the
produced.
submission of learned counsel for the
And
petitioner.
specify the inquiry report, he has not
There is serious
produced
question of,
any document.
serious question as to the right of the petitioner vis-a-vis the private opposite party involved herein. Also in the involvement of question of adoption, further also involving a question as to the private opposite party has any connection with the deceased involved herein. In this circumstance, this court find no protection by way of entertainment of a writ application can be granted in favor of the petitioner. Petitioner, if interested to protect his interest, has to approach the common law forum. This court therefore, while declining to entertain the writ application, simply observe dismissal of the writ petition at this stage as not maintainable in this circumstance shall not stand on the way of public authority if there is already any report establishing illegal public enrichment by opposite party number 5 through public action, if any. Yes.
Only I am showing my only one document, my lord. If your lordship permit, then
Huh?
only one document I showed before your lordship, my lord.
माइक अगर कौन तो अपन माइक रू 5 फुट दूर छुड़ा है.
Only with the permission, my lords, I will show only one document where the opposite party number 7 specified he is the.
That will create your right.
It's a legal aid certificate.
Please.
It's a legal aid certificate.
Please, I am not inclined. Yes.
Item 4.
I have given any public report is there, any action is taken, will be taken by public authority, there is no prevention.
I have repeated, but the public authority sort of the
Yes,
matter without
sort
taking
of.
any action, my lord.
All right. You are on a broader issue, therefore no writ will be entertained.
Obliged.
Yes, 4. Item 4.
Item 4. In this case, I am challenging the order dated 22/3.
Silent mic तळु करंतु मु प्रति केस रे जदि कहि माइक ऊपर करंतु तळ करंतु.
I am challenging the order dated 22/3/2023 passed by the officer on special duty LR Baliguda in RMC case number 5 of 2021, which is filed by the
Regulation
part number 5. Which is-
Regulation 2.
Where is the certified copy of impugned order?
Annexure 5.
Yeah, and so 5 is the impugned order. Where is the certified copy? I don't have a certified copy. I am only having a Xerox true copy. Find out if it is there in your office.
No.
Nahi, tale file kale kemiti. Without a certified copy, how could you file the writ petition?
7 days time permit to.
There is no filing of impugned, certified copy of impugned order and it's a 5. Even petitioner counsel doesn't have the copy of the same. However, considering counsel for the petitioner seeks at least 7 days time for production of certified copy of annexure 5, this court grant adjourn the matter to 10 days after the order becomes peremptory. Failure of filing of certified copy within 10 days by the next date of posting. The matter will be dismissed without reference to bench as it is not entertainable. Yes.
Item 5.
There is a very small issue. I have applied for certified copy which has not been given to me for my lord months together. That is under annexure.
Copy application is pending.
Pending ଅଛି ଆଜ୍ଞା 3 ମାସ 4 ମାସ ହେଲା.
Annexure 3
Annexure 3. Annexure 2.
pending
Annexure 2
before
and
OP.
OP तहसीलदार my lord that is.
ए माइक तळु करन सब केस रे कहयक पडुची माइक साइज करन ए
ଏଟା ଏମିତି ଅଛି ତ ତେଣୁ କହିଲେ.
सुन जुंतु के अच्छा आस गोटे ऑटोमेटिक सिस्टम करा ऊपर माइक टा हैंग हो हाइट देखि कि माइक तळ ऊपर हो आ कोन करबे आमे मु जदी प्रत्येक केस रे इठी लाइव होउची प्रत्येक केस रे आई विल बी आस्किंग द काउंसिल टू सेट द माइक टू देयर माउथ साइज ते लेखिकी रखिली
ନାଇଁ ଆଜ୍ଞା ଏଟା ଏମିତି ଥିଲା ମୁଁ କହୁଥିଲି 4 my lord.
Yes, OP for all right. So writ application alleging copy application annexure 3 has not been worked out by OP number 4. This court find these are unnecessary litigations. This is unnecessary litigation for inaction of the OP number 4. Well, in the process disposing the writ application, this court direct OP number 4 to find if there is no response to copy application annexure 3 series. Same should be acted upon forthwith by giving a lawful disposal to such application, at least within a period of 7 days of the service of copy of application. Free copy of order be handed over to Sri Panda for onward communication to the OP4. Yeah,
Item 6. OP number 3 my lord.
3. Okay, so OP3 kar do.
ଆଜ୍ଞା.
Item 6.
May I please your lordship?
Yes.
In this case, I pray for early disposal of annexure 1.
In the OLR appeal, notice has been already issued.
No notice.
No notice, then fresh admission. Okay, fresh early disposal kain koi douchandi. Fresh admission of OLR appeal 21/22 by OP number 2. By undertaking such exercise at least within a period of 10 days of supply of copy.
Item 7.
7, I am please, I am in VC, my lord. The annexure to page 11 submitted to before the authority for demarcation of land. Admittedly, they have inadvertently submitted before the collector. So I may be permitted to submit before the Tahsildar Jagatsinghpur OP4.
अपन client को advice न करी read petition काहे file कर?
से already दे जंती आउ
दे देले पैसा दे दी चंदी फेरे हबनी सेति में file कर देली. Is it a ground?
OP4 को direction to limited to disposal.
Counsel for the petitioner for there is misdirection in the representation annexure 2.
Page 11 annexure 2 their application.
Seeks permission of withdrawal of the writ application with liberty to file appropriate application before the competent authority for demarcation purpose. Permitted to be withdrawn, however, with liberty as spread for.
Item 8.
May I please your lordship?
Yes.
Your my lord, the petitioner has filed this application seeking a direction to the opposite party.
Notice to करिचंदी.
Notice करिचंती.
तेरा भाई दुई तादर किसी final outcome होनी.
Final order ही जाइए. I have already deposited the fees 3,500 so.
अपन deposit भी करती.
Yes, annexure 3.
एटा conversion case.
Conversion case.
तापरे कौन पट्टा बाहरनी?
Nothing, no pata barni, exactly. My lord.
Had submission of Sri. Your name is no, your power is not there. अपन power कहीं?
On behalf of Mr.
कहाँ केस है? फाइल करो तो 10 टंकिया आज कर देवे
संगे
अथवा तोर पुंजी ହେଲା ये सबमिशन ऑफ काउंसिल
Pikedas
making an accusation that
my lord Pikedas
ଅଛି power ଅଛି
ଅଛି
PK Das
PK Das all right seriously alleging in spite of a section 8A proceeding being entertained in 2000 and final order indicating the fee is required to be deposited for conversion of the disputed land. And even in spite of deposit of the required fees for conversion by Annexure 3 since 28/12/2002, there has been no preparation of the further record of right in the indicating the change in the status of the disputed land. This could find once section 8A proceeding is allowed and it is no further challenged. Further, in the event there is conversion fee already deposited, there should be attempt to prepare the record of right, further record of right in terms of section 8A proceeding order, at least within a period of 2 months of such orders, 3 months of such orders. Finding there is serious negligence, this court observe in the event the direction by the OLR 8A case number 13/2002-2003 has not been worked out in bringing out a corrected record of right, indicating change in the status of the land involved. Corrected record of right be brought out within at least 2 months from the date of communication of order. Free copy of order be handed over to State Council. Yeah.
Item 9.
Lordship, same item I have given the copy which is coming on 24/7/2023.
All matter it.
Urban Land Selling Act, Lordship, benefit
The-
under the Urban Land.
Yes, notice by way of service of copy. चला आरो केसटा 24/7 को अछि
आज्ञा
तो एटा भी 24/7 रे आसु
Copy दियो. Copy दियो.
matter to be listed along with WPC 14680 of 23.
extra copy sharp, Lordship, I am giving.
Item 10.
May I please, your lordship?
एमती कोन ओटे ना हला इस्राएल खान इस्राएल तक यहूदी
Israeli, Muslim, my lord.
इस्राएल तो यहूदी
Actually, my respectful submission here is that the petitioner
all right.
filed a disposal of the RP case.
readings are completed
Okay, my lord.
readings are completed
Pleading already completed, report from the
All right.
Tahsildar
Considering
settlement
RP
officer.
case 1574 of 2015 pending for over 8 years. This court direct the OP number 1 to take appropriate step for expeditious disposal of such RP case. At least completing such exercise within a period of 3 months from the date of communication of the order of this court. Free copy of order be handed over to State Council for onward communication.
Item 11.
My lord, item 11 case is subjected before the Additional Commission of Land Record Settlement, application 9 and 23.
Notice be issued in
No. Admit and native notice.
Fresh
That's no
admission.
issue.
press admission of the right.
Item 12.
Your my lord, I have challenged the order of the collector.
Defect remove करना कहेंगे advocate welfare clerk welfare fee देना थी वकालत ना मरे
Set my lord by the
এটা
caveat.
caveated
I have filed.
defect remove करନ୍ତୁ
First time ଆସିଥିଲା ଜାଣିଗଲା ପ୍ରଥମ ଆସିଥିଲା.
A similar
Yes.
matter, lordship have
Counsel
already,
for OP
notice has been issued and status quo has been granted.
seeks time for removing the defect. You let the defect in the caveat application as indicated herein be removed by Monday. Okay, yes, what is this case?
My lord, after my lord, we have purchased the land from the opposite
So
party
private
number
party
3.
has already appeared by way of
Yes.
caveat.
35, OCH case under 35 rejection. So notice has to go. Notice to
Notice
application.
you go.
Lordship से pass similar order.
appear କରି ଯାଇଛନ୍ତି।
आगे खाली
ତ
state
କଣ
को
କରିବା?
देबी
ମୁଁ ଆଉ ଫାଇନାଲ ହିୟରିଂ କରିପାରିବି
state को copy देबी extra
ନା ଏଇଟା ତ ଆଜି ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆସିଛି ଏଗୁଡା
First time.
state to copy the since there is already appearance by private opposite parties. Extra copies be served on the council appearing through caveat. Hala, miss case re as an interim. A counter if any within 4 weeks. Records involving the proceeding involved we also obtained by state council. IRA कर दो notice as above as an interim measure there shall be status quo in respect of disputed property to be maintained as on today to be maintained by both parties. Both
All
parties
accept.
involved here, you know?
other two matters also same other two matters same
Same. All right.
same parties my lord
Defect टा केवल first case रे
हाँ।
ଅଛି। आर केस रे भी आपण appear कर जाउचंती
आगे
caveats
caveat
ओके सबुथिरे डिफेक्ट अछि caveat देइचंती थर्ड केस रे भी
ସବୁଥିରେ ଦିଆଯାଇଛି।
थर्ड केस रे तो caveat शो करनी सेकंड केस रे caveat शो करनी
ନାଟା ବାହାରିଛି
ना
ନା
ना बाहरची
आगे
ऑल राइट ताले सेम ऑर्डर कर दे ओके ऑल राइट
Item 13,
yes
The petitioner challenges the order dated 27/4/2030.
you are the return candidate or
Rejected my recall
you are election petitioner or return candidate
election petition.
election petitioner so what order has been passed
First, the day was fixed, the petitioner was suffering from ill and filed the time petition. Thereafter, the Lord Court below closed the evidence. For which,
therefore it has been rejected for having
on the ground of the court
no
cannot,
jurisdiction right then what is the illegality you may challenge that order you may challenge the order which you are filing a review or recall petition you are not challenging that here
the recall petition already have rejected.
okay, right why you file a recall petition once he has passed an order you should have come to higher court so what do you propose you will withdraw this
With the said observation.
yes, petitioner wants to withdraw the writ application and may attempt for with liberty to attend for challenging the order dated 25/4/23. But why you are unnecessarily lingering the proceeding? You are the election petitioner. You should allow Agurubi High Court direction deichanti for early disposal. You have taken early disposal order. Now you are putting applications after applications. Why are you creating these obstructions? आपण चाहुनाहांती election proceeding टा सरू बोली why you take this liberty even it's your application you should be interested in early disposal of the proceeding don't press this court find there is already order on being asked by the election petitioner for early disposal of the writ application the election dispute involved herein in such situation this court, even though permit the petitioner to withdraw the writ application, however, doesn't grant any liberty. Yes. Petitioner is directed to cooperate the authority for early disposal, timely disposal of the election dispute. Yes. Yes.
item 14,
That's a matter of infrastructure permit to withdraw.
Petitioner seeks counsel for petitioner seeks withdrawal of the writ application as it has gone in process. Dismiss as in process.
item 15,
May I please, your lords. My lord, the present petitioners are challenging the illegal construction made by the.
For what?
My lord,
Your annexure 4 is pending.
Annexure 4 is pending. We have filed before the collector and that has been sent to OP number Tahsildar Bhadrak, my lord. OP number
Where do you find that? Okay, all right.
5, my lord.
All right, it is alleged based on the complaint of the petitioner on annexure 4, even though matter has been referred to Tahsildar for appropriate action, As clearly borne at page 14 of the brief, there is no further action considering serious allegation to be serious involving inaction of the Tahsildar Bhadrak. Matter stand disposed, directing Tahsildar Bhadrak to give an outcome to the direction of the collector by Danesha 4, page 14. Working it out in the involvement of the party likely to be affected following due process of law, at least within a period of 3 months.
My lord, may I permitted to say in the already OP number 6, my lord, has constructed one poka house. Chhato bhi agya poka.
What is the remedy available? It is your land.
Land belongs to my lord National Highway Authority of India.
Authority. So National Highway Authority को approach କରିଛନ୍ତି ଆପଣ से पठेଇ ସାରିଲେଣି ତହସିଲଦାର କୁ inquiry.
ଆଜ୍ଞା.
Is any interim order possible at this stage?
No, my lord, my application may can be considered within a stipulated period.
Direction ଦେଲି ପରା.
ଆଜ୍ଞା.
Yeah.
Item 16.
You may move an application there.
My lord.
ତହସିଲଦାର ଯେତେବେଳେ inquiry କରିବେ ତାକୁ involve କରିକି
ଆଜ୍ଞା.
you may move an application that sir construction is getting progress. So at least till a decision comes, there should be stay of the construction. सेठी move करंतु.
आगे.
हाँ.
May I please, Your Lordship? The petitioner before Your Lordship and opposite party number 5 are contested, private opposite party number 5 are contested for the ward member. And from date of nomination, it was alleged that opposite party number 5 has more than 2 children. But nobody cared that after interference of this honorable court, collector instituted a GP miscase.
You earlier came here and it was directed to bring a 26.
Yes, that has been concluded.
Yes,
I did
it is concluded.
That has been concluded.
Annexure 7.
Against you.
Annexure 7.
Concluded by Annexure
7.
7.
Annexure
7.
7.
Page
23.
Page number 23.
So it has to be
Yes,
page
notice has to be-
23. Where is the certified copy?
Certified copy is with me.
ଆପଣ କେମିତି ରଖି ଦଉଛନ୍ତି?
File କରନ୍ତୁ.
File
File.
କରନ୍ତୁ immediately with the memo. ଏଟା କ'ଣ electronics filing?
No electronics.
So if it is a filing in court, electronics filing रे circular issue ହେଇଛି, ଆପଣ retain କରିବେ certified copy with you. But if it is a filing in court,
Okay.
then you have to produce that.
I will file.
Counsel for the petitioner undertakes to file the certified copy of Annexure 7 in course of day.
In course of day.
Okay. Issue notice on the question of admission, fixing short returnable date. Requisites accordingly kariba. All right, you take notice. Matter will be listed immediately after appearance of the private opposite party. Requisites by Tuesday.
Within 6 months, they will make a fresh election.
Pardon?
Within 6 months, they make elect.
Listen, once a notification comes, you may come to court.
Oh,
Since a proceeding is pending, there should not be any notification. If they bring a notification for fresh election, you have a right to approach for
yes.
stay. Otherwise, your matter become infructuous. So come at that point of time.
Okay.
But the miscase is not fresh for the time being. ଅଛି କି miscase file କରୁଛନ୍ତି?
ନାଇଁ
ଆଉ fair କରୁଛନ୍ତି? Consciously, you have not filed any miscase.
No.
It will be done. Don't worry.
Hey, extra copy to the government and only one
ଆମେ
notice.
କରିବୁ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି ଆମେ ଦେଖିବୁ cost title ଦେଖିକିରି କାହାକୁ notice ଯିବ କାହାକୁ ଦିଆହବ that I am living with my staffs. You need not worry.
Obliged.
ନହେଲେ କଣ ହବ କି madam?
Item 17.
May I please, Lordship? Lordship, the petition is the 90 years old, Lordship. Limited by directly
ଏଥିରେ
open number.
notice sufficient ହେଇଗଲାଣି SRP?
ନା
Keep a case admitted. Admitted.
ହେଇଯାଇଛି. Okay, this is a writ application for expeditious disposal of SRP 115 of 21. Provided pleadings complete, attempts should be made in the final outcome of the proceeding, at least within a period of 3 months from the date of communication of order. But in the involvement of party likely to be affected. Yes.
Item 18,
May I please, Your Lordship, my lord, my lord, that annexure 1 is the transfer application. Wherein I
Third
have,
party transfer, have you served a copy on Mr. Mahapatra?
my lord, because it was a.
Copy diyantu.
Again, I'll serve a copy.
Kebe aniba? Next Friday aniba?
Kahar?
Yes, let 2 copies of the brief be served on Sri Dayanand Mahapatra, who usually appears for the contesting opposite parties. The Mahapatra also, consequent upon service of copy, as directed herein above, Sri Mahapatra and counsel also directed to obtain instruction on the allegation of the petitioner to be placed on the next date of posting on Friday. Please.
My lord, here a notice to OP number 4 may be necessary.
item 19,
ଆପଣଙ୍କର ମୁହଁ କୋଉଠି ମାଇକ୍ ଟା କୋଉଠି?
I'm sorry.
କଣ ଏଠି କରି?
I'm sorry, my lord. I'm sorry. My lord,
ତାହେଲେ ବାର ରେ ଯାଇ ଡେମୋନଷ୍ଟ୍ରେସନ
necessary in this.
ପ୍ରାଇଭେଟ
case.
ପାର୍ଟି ଅଛି?
My lord,
ପ୍ରାଇଭେଟ ପାର୍ଟି ହେଲେ ତ ସମୟ ଲାଗିବ ତାର।
my lord.
But third party, he must be interested party.
No, my
କାହିଁ
lord,
ସେ ତ proforma?
11 ବର୍ଷ ରହିଲା ପରେ ନା, now he has raised an objection.
He has raised the objection.
11 years it was pending.
Or then notice has to.
My lord.
Notice ପଠେଇଦବା। Notice
ଏଠି ବି ଆଉ କିଛି ହବନି ଯଦି objection raise କରିବେ
extra copy ଦେଇଦେବେ ମହାପାତ୍ରଙ୍କୁ
ଅଲଗା
for
ground.
2 and 3. State କୁ extra copy.
ଯାହା ବି କଲେ ବି ହବନି ହଉଛି।
That to be placed.
May I
2 weeks
submit
after
matters?
the sufficiency of notice. Counter if any be filed within 1 week of the service of notice. ଯଦି objection କରିଛନ୍ତି ଆପଣ proceeding close କରୁନାହାନ୍ତି କାହିଁକି?
କ୍ଲୋଜ ହେଇଯାଇଥିବ।
ନାଇଁ ନାଇଁ ମୁଁ RTI ରେ ମାଗିକି
କାରଣ objection ଥରେ ହେଇଗଲେ unless specific performance of contract we can have we don't have any.
Pendency of the writ application shall not stand on the way in giving a lawful disposal to objection if any pending with the development authority.
Yes, ma'am.
Obliged.
item 19,
Item 19.
Item 19, my lord, I'm appearing through virtual mode.
Yes.
In this case, my lord,
Gown kahin ଆପଣଙ୍କର?
but I'm wearing the gown, my lord.
ଅଛି, all right.
ଅଛି।
I'll never do the procedure.
କଣ instruction ଆଣିଛନ୍ତି?
Matters
The
I
counter
file
has been
counter.
filed by the-
Matters
The file counter.
Yes, matters. A pre-possession transfer matters. All the 3 cases are pre-possession transfer.
Okay.
There matters what happens post-possession transfer. Matters have given direction and accordingly government made a instruction resolution. And I have given it in annexure B by 2 matters. Annexure B by 2 page 11 to my counter.
B by 2.
2 page 11 to my
সেটা আমার কাউন্টার না।
So but that doesn't cover the case of the petitioner. It is
but pre-possession and post-possession both are all
standing. It is rather better footing.
But kindly, but the thing
So
is that
therefore I am extending my judgment to this case.
that thing is that minus extended. But kind of class to annexure B by 2. This order should
B
be
by 2.
B by 2. But what happened? Kind of a class 2.
Mike ଟା ଟିକେ ତଳକୁ ଆଣନ୍ତୁ।
Kind of a class 2 page 12. 12 page 12.
Yes.
Government, last part, government
Yes, after careful
for consideration has been pleased to permit the allotee getting 1 plot house plot through fair means and by following prescribed procedure and provisions and for transfer of such allotments in favor of legal heirs of the original allotee
this covers the petitioner.
Under the category of post-possession transfer.
Only. So it is confined to post-possession.
My humble contention is twofold. Question is that post-possession transfer itself says that it is a third party. It's not the legal heirs. Legal heirs are the origin, they are stepping to the shoe of the original allotee. So if it is restricted to post-possession, obviously third parties are deprived. Third parties are deprived of that. Then the GA department has issued that circular. In view, of course, they have taken note of minor's decision. That is the second paragraph.
Yes.
The case has gone to Honorable High Court, where Honorable High Court has opined that such cases are not coming within the purview of the assignment of task force, and hence has directed for execution of the lease deed with transferee on payment of registration fee for all first lease deed with originality, and then stamp duty and registration fee for the second lease deed with transferee. So the transferee comes.
So you have the obstruction for this circular.
Yes, ma'am.
That's all.
We are bound by that circular.
So is this circular challenged here?
No, but this circular, I think the circular they have not challenged.
My lord, this, so far as this resolution is concerned, my lord.
Okay, that
it was-
circular cannot be also challenged because
Yes, no,
the judgment
this
was only on
passed-
post position.
On post
This
position.
was, yeah,
Transfer
this was
from
passed,
post
my lord, this
position.
was passed. This was passed during the pendency of the writ petition, my lord. It's dated 30th. June
Yours
2020.
is a pre-possession transfer.
My lord, my respectful submission is, my lord, the government has completely misread your lordship's judgment. My lord, if I read out just few paragraphs of your lordship's judgment,
Yes.
in no uncertain terms, your lordship has held.
Which para you want to read?
Your lordship may kindly turn to, your lordship may kindly turn to, your lordship may kindly have the second brief, my lord, that is of Samir Kumar Mahanti.
Second read the law. But the judgment is here.
Kai यही case है देखो ना दी page
It
30.
is very clear, my lord, they have completely misread your lordship's judgment.
So which para you want to read?
Yes, my lord, paragraph 3 of the judgment.
3.
Yes, my lord.
Yes, read para 3. It is available at page 29.
Yes, my lord. Paragraph 3, my lord, your lordship would see the last sentence. Mr. Mahatra, learned counsel appearing for the Development Authority, however, has no denial on the terms of reference aspect involving the task force report and submits in any case there cannot be avoiding of one registration charge involving initial allotment and stamp fee and registration charge for entering into direct registration of the lease date with the petitioner as the subsequent allottee. Mr. Panda, learned additional government advocate, however, while supporting the stand taken by Mr. Mahapatra, learned counsel submitted in passing the final order, there should not be any loss of revenue. Mr. Panda, additional government advocate, however, did not dispute the terms of reference involving the task force report, and that there has been a recommendation of task force report at para 48 while annexure 9 not applying to the case at hand.
Mr. Roy, principle decided therein squarely applicable to you.
Yes,
Because
my lord.
this was also not in terms of reference to the task force.
Yes, my lord.
Okay, therefore, let me clarify the position. That judgment will be
And
applicable.
paragraph
to
5,
your-
my lord, paragraph
your
5
case
is very
also.
clear, my lord. Where lordship has held that third party transferees was never the mandate of the task force committee. The only mandate of the task force committee was in respect to discretionary quota.
Oh,
and multiple
again, you are
allotments.
repeating that.
Yes, my lord.
You are at a distance, therefore you are not following us.
But
No, no,
that
no.
is exactly my lord, the resolution.
So now what is the impugned order here?
Impugned order, my lords, the pre-possession transfer that has not been allowed. They say,
Annexure?
not annexure. They say that execution.
They have not
lease deed
taken
is
a
not
decision, my
executed.
Huh?
Lease deed is not executed
Not executed.
in view of pre-possession. And then, my lords may point out one part, my lords. Another aspect, my lords. Thing is that here in this case, pre-possession and post-possession. In this case, was pre-possession and post-possession. Earlier, my lords have given direction in case of post-possession. My lords categorically held that yes, these are not within the purview of the task force. Considering this judgment, my lords, the resolution of the GA department has come. Says that it will be applicable for post-possession. My humble contention, of course, supporting the petitioner or opposing petitioner, it is not my case, just to point out. Here in this case, only the concept of transfer will, post-possession will come in case there will be transfer. Either pre-possession or.
Now I will be giving a judgment.
Another thing is
giving judgment, another notification may come out.
But that is the thing. That exactly, my learned brother is there, that will pass the judgment. Only thing,
But there my learned senior is wrong.
Question
because
is that
lordship has
it is a
never-
pre-possession or post-possession.
Your lordship has
It
never
is a lease
said
deed.
it's pre-possession
But
or post-possession. Your lordship has categorically said.
Submit karisaru.
Please. But it is a pre-possession or post-possession, that is one aspect. The second aspect, my lords, if this is escaped out of the pre-possession, then contingency come, he holds a plot. But he has to file an affidavit that he doesn't hold a plot.
Then the necessary formalities have to be complied.
Complied with, but then they have to,
I will only observe there should not be any difficulty or embargo in entering into a lease deed or execution of a lease.
Yes,
deed.
they have to file an affidavit to this.
But that will be again subject to other mandatory compliance.
Yes, that exactly.
That cannot taken away by my judgment.
They have, what happened? They have to file an affidavit that yes, they don't
Oh, that
possess.
stage has not come.
Not-
Now you are not
that's-
entertaining the application.
Yes,
even.
yes, madam, yes.
For the government notification, you restrict it now to the post-possession transfer.
Certainly.
So now this will be a judgment for pre-transfer also covering the case, and necessary formalities are to be complied.
My lord.
সেটা কম কি মনে কর দাও?
No, no, no. So that aspect.
Yes, had the
May I clarify only one thing, my lord? May I clarify only one thing, my lord?
yeah. You are creating complications.
I'm sorry,
I've
my lord.
already
I'm
made
sorry.
up my mind, you are not understanding. That's the difficulty when counsel appears in VC, that's the difficulty.
My lord,
ଆପଣଙ୍କୁ ଅଧା ଶୁଭୁଥିବ ଆପଣ ଅଧା ବୁଝି ପାରୁନଥିବେ ଏଠି କଣ ଚାଲିଛି
due to
discussion.
some difficulty, I'm there, my lord. Otherwise, every time I ensure that I'm there before my lordship physically, my lord. I'm sorry, my lord. Your lordship.
You have a counsel here. You are there. All right. Yeah. Mr. Mahapaତ୍ର, take your seat, Mr. Bose. Things are clear, Mr. Bose. Task force, there is particular reference. Reference never covered these issues. He has gone out of the reference, scope of the reference, and he has given some suggestions. I have already held in my judgment. The terms of reference is binding on the authority giving a opinion. You can't go beyond that.
Yes.
And secondly, I said, since this was not in issue, and there should not be any embargo. What is the difficulty? Upon permission to those
Rather, in our counter, we have said that now the ball is in the court of BDA.
BDA. Therefore,
That exactly we have said in our.
no, he has the difficulty for
Yes, that your lordship will
the
clarify.
notification, but notification is obvious. There is no defect in the notification. Notification is strictly in terms of the judgment. Therefore, they say, once government is not clearing air, with
further
regard to the pre-possession, we are helpless.
If further clarification is required by
Judgment
this.
has to come only. এটা judgment হবে. Repetition involves the following prayer. Reading the prayer, the allegation here it appears to be petitioner. You are the owner in on transfer pre-possession.
Yes, my lord.
You are the present owner.
Yes, my lord.
Owner in possession of the land. Transferred at the stage pre-possession by the competent authority.
He is the purchasee, my lord. He is not the owner. Owner sold the property in their favor after taking permission.
Now in possession, party in possession. Party in possession, receiving the property of the actual owner, but pre-handing over of possession stage. Making an application for execution of the deed on 2/5/23 by Dhaneshwar rate is not being worked out. Further, petitioner also makes a prayer for considering the representation dated 2/5/23 by Dhaneshwar rate, keeping in view the observation of this court in the judgment dated 12/10/22 in WPC 12489 of 2022. Also find place here as Annexure 7. Plot involved herein appears to be HIG plot bearing K-8/255 under Kalinganagar plotted development scheme plotted by Bhubaneswar Development Authority. Background involving the case appears to be one Chandrakant Mahapatra was the original allotee of HIG plot bearing number K-255 under Kalinganagar plotted development scheme. Bhubaneswar White, registration number URD all capital /00022/88 It is on the request of the Chandrakant Mahapatra, the HIG plot bearing number K-8/255 ସବୁଠିକି କରିବ 255 ହେଲା ସେ ତାଙ୍କର କନଫ୍ୟୁଜନ କରିଛନ୍ତି କୋଉଠି 225 ଲେଖୁଛନ୍ତି କୋଉଠି 255 ଲେଖୁଛନ୍ତି 255 was transferred in the name of the present petitioner by BDA by its office order dated 21/1/98, who has even deposited the amount in respect of the said plot for being transferred in the name of the petitioner under the same terms and conditions. Undisputedly, Development Authority already handed over physical possession of the said plot to the petitioner through an amin on 31/1/2006. In the meantime, it appears in 2010, Development Authority accorded permission for construction of a double-storied residential building over the plot involved, again in favor of the present petitioner. Even in the meantime, in 2011, there has been issuing of a no objection certificate in favor of the petitioner for purpose of mortgaging the plot with State Bank of India, subject to execution of a tripartite agreement in terms of BDA format, BDA capital. On the strength of NOC, a tripartite agreement has also been executed in the involvement of the petitioner, Development Authority, and the State Bank of India as well for availing bank loan. It is alleged for intervention of a task force committee report, there has been creation of difficulty in regularizing the plot in favor of the petitioner. The petitioner further claims for the observation of this court in the judgment in WPC 12489 of 22, delivered on 12/10/22, compelling the petitioner in bringing the writ application with the aforesaid prayer. On notice, there has been filing of the counter by respective opposite parties.
But only PDA, not by the government.
No,
We have filed.
PDA.
We have also filed.
Yes, OP1 has also filed a counter, shifting the ball to your court.
That I have not received.
I am having all this.
I have not received. I will get the copy.
Thank God a copy they did. He made it clear. He said we have filed counter, but we have shifted the ball to the BDA. Yes. The counter affidavit on behalf of OP1 basically shifts the burden on the Development Authority. So far, it relates to claim of the petitioner based on the judgment indicated herein above. OP number 1, however, said judgment has clarified the position. Judgment referred to. And it is for the Development Authority to take a decision on the pending application of the petitioner, as reveals in paragraph 4 of the counter affidavit also taken help of para 11-12 in the said judgment through their amendments in para 6. In the meantime, Development Authority OP number 2 has also filed a counter affidavit. The counter affidavit, even though did not dispute the position as stood by today on the basis of the judgment referred to herein above, followed by a government notification by Annexure B/2 covering the case of the post-allotment cases. There is, however, objection on the application of the judgment on the premises that judgment never considered the case of pre-possession deliveries. Development Authority, however, serious banking on the restrictions through Annexure B/2 submits, they remain undone.
Paragraph 7 of the counter of the opposite part number 1. The categorical said it is for post possession.
Sri Mahapatra and counsel appearing for the Sri Roy counsel appearing for the petitioner were reiterating the aforesaid recordings and strongly relying on the observation of the judgment on the applicability of the task force report to the case at hand being thrust out through the judgment in WPC 12489 of 22. Sri Roy also advanced his submission on Annexure B/2 stating Annexure B/2, though strictly not applicable to the case at hand. However, the observations of the competent authority running page 64 squarely covers the case of the petitioner, as the competent authority has already understood the excess action of the task force thereby also covering the non-issues, touching the non-issues with it and giving recommendations on non-issues. The Mahapatra Learned Council, while reiterating the counter arguments of OP number 2,
OP number 1, para 7. OP number 1, para 7.
banking on
OP number 1, para 7. They said it is for post possession.
Speaking this court to the plea of opposite party number 1 in para 7
Post possession transfer cases.
submits the judgment covers post possession transfers. The consequential notification of the government also covers the case of post possession. There is, however, no denial that there is no decision on the representation of the petitioner as of now. Sri Mahapatra therefore claims this is a pending case and liberty should be granted to the opposite party number 2 for taking a lawful decision on the same, instead of taking a decision at this stage of the matter. He is considering the rival contentions of the parties. This court finds the dispute involves the following issues. 1. If there was a reference dealing with the cases of pre-possession deliveries being conducted by the task force. 2. For there is already a judgment protecting the post-transfer possessions. The pre-possession transfer stands in a better footing. The judgment should have also application to the case at hand. It is considering the aforesaid questions involved herein. This court from the undisputed facts finds originally the disputed land was assigned with one Chandrakant Mahapatra, being the original allottee. In the meantime, there has been request by Chandrakant Mahapatra OP number এটি করছেন কি চন্দ্রকান্ত কো পার্টি?
No, my lord, no.
Okay, Chandrakant Mahapatra, the originality makes a request to the development authority for transferring the name of the owner involving such plot in favor of the petitioner. There is no denial that development authority not only passed order on 21/198 permitting such transfer. In the meantime, development authority has already transferred the physical possession of the plot to the petitioner. Matter did not end there. After such development, there has been even agreement at the instance of development authority in issuing no objection certificate in favor of the petitioner alone for the purpose of mortgaging of the plot with State Bank of India to avail bank loan. In the process, there has been also entering into tripartite settlement, also in the
agreement,
tripartite agreement, also in the involvement of the development authority.
Permission granted for construction. Permission also has been granted.
Yes. In the meantime, in another development, there has been also permission to go ahead. There has been plan approval at the instance of the petitioner, and a building has already come to stand over the disputed property. In the involvement of huge loan amount, in the agreement and issuing of no objection by the development authority. This court here observes, this is a case, the case since involved transfer of land, pre-possession, pre-handing over of possession to the original allotee, stands in much better footing than the delivery of possession in case of post-possession cases. Petitioners in stand. Okay, now coming to the other aspect involved herein, if the task force exceeded its jurisdiction in opining on non-issues, this court, considering such issue, in the delivery of judgment in WPC 12489 of 22, has already come to observe
Paragraph 5, my lord.
in paragraph 6 the term of reference to the task force, which reads as hereunder. Case 30 ରେ ଅଛି term of reference ଟା a para 2 ରୁ ଟିପିବ ହେଲା. It is in the above background, in the judgment, in the aforesaid writ application, this court has clearly held the task force unnecessarily entered into non-issues and delivered its opinion on non-assigned issues. Further observing, opinion, if any, on non-issues has no binding effect. In allowing the aforesaid writ application by the judgment dated 12/10/22, there has been further development. State government, in acceptance of the aforesaid judgment, has already issued a notification. Annexure A/2 is the notification.
Annexure A/1 in the count.
A/1 is the
Counter of the opposite part.
Our counter.
huh?
Our counter.
My count of the annexure B/2.
नहीं आपको ये टाउची B/2. A/1 yours.
Yeah.
Okay, as appearing at government has already issued notification in acceptance of the judgment, in wholeheartedly acceptance of the judgment by annexure A/1 to the counter affidavit of OP1, so also annexure B/2 to the counter of OP number 2. Now, for the observations herein, and the petitioner since stand in better footing than the cases involving post-possession, the judgment has clear application to the judgment delivered in the aforesaid case has also clear application to the principle, and the judgment are clearly applicable to the pre-possession cases also. In the process, this court, in allowing the writ application in the aforesaid, with the aforesaid observations, direct the development authority to give an outcome to the representation of the petitioner pending at its end by annexure 8.
Annexure 8.
Annexure 8, Mr. Rai.
Annexure 8 minutes.
My lord, actually, my lord,
Representation annexure 8.
annexure, my lord, that brief I don't have with me, my lord. I have the earlier brief by
Annexure 8. Annexure 8.
Annexure 8. See, only to say yes or no. Please come to court when hearing matters are taken up.
Page 35.
No, this creates problem here. I am hearing a matter to deliver a judgment. You are not properly assisting.
I'm sorry, my lord.
Yes. To give a lawful disposal to annexure 8, keeping in view the observations herein, so also the observations in the judgment dated so and so in WPC so and so, by giving an outcome at least within a period of 6 weeks of the communication of the order by the petitioner. If this court hope and trust, there should not be any embargo in the entering into lease agreements. It are lease lease agreements required for the purpose. Which action may also be completed within 15 days of
Lease deed. That will be lease deed. That will be lease deed.
Sell deed
Lease deed.
Lease deed. Okay. Lease deed. Yes.
Time.
1 month there. 1 month there.
Subject to compliance of other conditions.
Petition succeed, but to the extent indicated here in above.
Other conditions, we have to examine other conditions. We have to examine other compliance.
Okay, allowing the writ petition may not be construed that there has been exemption of the other statutory conditions in before entering, required to be complied by parties involved before executing the lease agreement.
Lease deed.
Or lease deed. Okay. Yes, judgment above. Aradhita case re karibo.
NOC support NOC nahi.
Issues involved herein is already considered and decided by way of judgment in WPC 18169 of 23, which squarely covers the case at hand. Direction therein are, shall also govern herein. The writ petitions thus stand disposed. It may be open to the petitioner for providing copy of order of this case along with the judgment in 18169 of 23. Okay. Same order in 18172. Yes, right.
Item 20.
Grateful, my lord.
Please cooperate. Come to court in hearing matters. I will not undertake any hearing through VC.
Today I have got some genuine difficulties.
This creates problem in me.
I'm extremely sorry, my lord.
Yes, item 20.
My lord, item 20, I have not filed a counter to I have not filed the counter to his time required for filing counter.
Time. This is a passport matter or?
No, my lord. A railway matter, my lord.
Okay, any interim order operating? Yes. Okay, State Council, Council, PK Padhi, DHI, Central Council. The Padhi 6 for the time. Kete samay chahuchandi?
4 weeks time.
4 weeks time for filing the counter. Matter stand adjourned to 6 weeks. Interim order shall continue till final outcome of the writ application.
Item 21.
At 21, in this case, the petitioner has only sought prayer. He is claiming that the Biju Setu has been constructed in that
Land belong to you.
no, my lord, the approach road will be
Then this
102.
will be a matter under OPLE.
My lord, I am already, they are not
No. Under which provision of law this action will be taken?
OPLA.
So then it will go to OPLE court.
Only I have not.
Action of the competent authority desired under OPLA Act. Matter may be placed with the assigned bench.
Item 22.
Yes.
May I please your lordship? My lord, this is a case where, Lord, this is a case where the petition is challenging the order under annexure 1 passed by the ADM Khurda
Permission under section 22.
has been rejected by both the courtmen.
Then why you approach High Court? Why you approach High Court? You can move an application to the competent authority.
Perhaps after the order of the appellate authority.
Okay, there has been orders rejecting.
Yes. Annexure 1.
Then take notice.
Annexure 1 and 7.
Notice on the private party achanti ki?
No.
Only government.
Government.
Notice kar diyo. Records in revenue miscase 14/22 and OLR appeal 1/22 be obtained by State Council. Apa certified copy of impute order file karchanti?
Annexure 1 टा file करছি 7 टा.
Annexure 1.
1 होचे annexure.
That's appeal order. All right. Well, it extra copies kar dobo. 5 extra copies to sir. Okay. Counter if any, we are counter if कौन होगा?
Counter किना record टा खाली आसियो. से सोना proceeding.
Okay, State Council discuss with the competent authority. Matter may be placed for final hearing after 6 weeks. Dita ka matter se?
No. Next matter is relating to order 23(3)A petition. Order section 23A.
There is also rejection.
Yes, ma'am.
Here you have filed certified copy of the
yes, Mr. One.
there. All right, it will say notice kar diyo. Same order kar diyo. Eta OLR appeal record aslo. Next.
Item 23.
23, my lord. Here in the petitioner participated in the auction process of a property of Gram Panchayat. Stood the highest bidder.
Power kind.
Power ta, my lord, on behalf of Mr. Mohan.
On behalf of one. It's a loss of revenue to state.
My lord,
appearance memo diyo.
appearance memo.
They in course of day.
My lord. My lord, he stood highest bidder. They have accepted the amount, but not executing the agreement deed and not handing over the possession, my lord, since 2/6/2023.
2/3/23.
2/6, my lord.
2/6.
More than 1 month. They have accepted the amount of 88,500.
And it's 2 is the receipt.
My lord.
Okay, through the writ application, a serious allegation is made. Even though the auction has been deeded in favor of the petitioner, and even after receiving the auction amount by Annexure 2, there has been no execution of the deed required for the purpose. Handing over helani possession.
Possession handing over hai para.
There is also no handing over of possession. Provided there is no lawful order, the order of competent authority obstructing such execution, all out attempts should be made in executing the required deed and in the transfer of the disputed property in favor of the petitioner for his operation in the lease period by working it out at least within a period of 15 days of the communication of order. Free copy of order be handed over to State Council.
No, let us GP Gram Panchayat. State has no rule. The Gram Panchayat auction korchi, Gram Panchayat tankar
Gram Panchayat executive officer.
Served on the Panchayat.
Yes.
OP number?
OP number 4, my lord.
पर लिखी दो Sri Mishra undertakes to file requisite fee stamps and the appearance memo in course of day. Yes. Next.
Item 24.
Obliged.
Yes. Pleading complete is if the pleading completed in appeal case number 11 of 22, if notice has been issued at all there, notice issue.
Notice issue.
Okay, Sri Guru Learned Counsel for the petitioner makes it clear that there has been already entertaining of the mutation appeal 11 of 22 by OP number.
We have not made the court party, my lord. Sorry.
OP karna hai by the appellate authority involved herein, the sub-collector, Sadar Sambalpur. In the event notice is sufficient, all out attempts should be taken for giving a lawful disposal to the mutation appeal, case number 11 of 22, at least within a period of 3 months of the communication of order. But in the involvement of the party likely to be affected.
Item 25.
May I please your lordship?
Yes.
By these writ applications, the petitioner is seeking for a directions to the opposite party number 3.
Direction 1.
OP number 3, my lord. Similar order has been passed by this honorable court.
Similar order thile aguru taଙ୍କୁ ସବୁ copy ଦଉନାହାନ୍ତି କାହିଁକି? It is implementation of 15B order.
Yes, my lord.
There is possibly direction for correction is in the light.
Yes, my lord. RPO is allowed in favor
Is
of.
allowed. Tahsildar is directed to record purchase land.
Yes.
Involved ଅଛନ୍ତି ତ ଯଦି କୌଣସି
ସେଠି ଇଏ ଚେଞ୍ଜ ହବ ହେଲା ଏଟା ପ୍ରେୟାର ଟା ଚେଞ୍ଜ କରିବ ସିମିଲାରଲି ଆରପି କେସ୍ ନମ୍ବର ଗୁଡାକ ବଦଳିବ ହେଲା ଅର୍ଡର ହବ yes ମୁଁ ସେଠି କରିଛି provided the order is not interfered by any
yes ସେତିକି
yes ଦିଟା କ ସେୟା
Yes,
case number careful ରହିବ
May I submit one another 2 cases also filed but not
କଣ
listed.
କରିବା
Another.
କାଲି ଏ ସୋମବାର ନେଇ ଆସ
May I give the numbers?
ଆରେ ବାବୁ ସକାଳେ ଯଦି କହିଥାନ୍ତେ ମୁଁ କଲ୍ ଫର କରି ଦେଇଥାନ୍ତି ଏବେ ହେଲେ କେମିତି ହବ କଣ କରିବା ସିମିଲାର ମ୍ୟାଟର ନେଇ ଆସିବା ଦିଟା ବେଳେ ଦିଟା ବେଳେ ଆସନ୍ତୁ ଦିଟା ବେଳେ ଆସିବେ ହେଲା ସ୍ପେଶାଲ ନୋଟିସ ରେ ମ୍ୟାଟର ଆସିବ ମଗେଇଦେ
Item 26.
Petitioner, the election petitioner. Petitioner, the election petitioner.
କିଛି ଶୁଭୁନି
Milord,
ଆପଣ କାହିଁ ନଇ ଯାଉଛନ୍ତି ମାଇକ ଟାକୁ ଉଠଉନାହାନ୍ତି ଏମିତି ତଳେ ବସି ଯାଇଥିବ ଆଉ କଣ ଶୁଭିବ ମତେ
pleadings complete and evidence.
who are you? You are the election petitioner.
Milord, I am the election petitioner.
Why it is being lingered? Evidence comments करनी
Milord, pleadings
cross examination of P3 हेलानी
everything is over.
PW3 रो cross examination हे गला
Page 14, kindly see.
Okay, by filing the writ application there is serious allegation on unnecessary adjournment of the election proceeding at the instance of the respondent therein. Counsel for the petitioner attempted to establish such issue through the order sheet filed herein. This court finds satisfied with the allegation of the petitioner and in disposal of the writ application directly, election tribunal for expeditious disposal of the election miscase 2 of 22, at least within a period of 3 months of the date of communication of order. And without entering into unnecessary adjournments.
From the date of production of certified copy. From the date of production.
Definitely. Yeah. It goes without saying. Yeah.
Item 27.
May I please listen? The petitioner is the recorded owner of the land, my lord. Now the opposite party number 2 tried to going to make a
All
pakka
that on the self same issue. Annexure 4. Repentation pending before OP.
OP number 2, my lord.
2. OP2 thus directed to give a lawful disposal within 2 months of communication of order along with copy of writ petition.
Oblige, my lord.
Item 28.
Okay, may I please, Your Honor? The petitioner filed this writ application for a direction to the opposite party number 2.
Not accepting the rent.
Rent.
All right, on self-same issue, annexure 3 pending before OP number.
OP number 3, man.
Two.
2. Tahsildar.
All right, directed to give a lawful disposal to annexure 3. At least within a period of 1.5 months from the date of communication for free copy.
Published.
Order along with copy of writ.
My lord.
Yeah.
I don't.
Covered matter, my lord. Consider annexure 4, my lord. Referring.
Yes, sir. All right, annexure 4.
Item 30.
You know the file Royce actually.
May I please, Your Lordship? My lord. Annex of 3 under challenge, my lord, arising out of a 37 order passed under section 37(1). My lord, here is the case.
That was the order passed in 2015.
My lord, behind my back, what happened here? My lord, the present petitioners are the legal heirs of the Radha Pradhan. My lord, your lordship kindly see the impugned order.
It's an unreasoned one. Page 26, there is no reason. I have perused so and I am not satisfied. At the submission of respective counsel, writ petition involved following prayer. Taking this court to the impugned order annexure 3, running page 26 of brief, there is serious allegation of disposal of a statutory proceeding without assigning any reason and findings. Considering the rival contentions and on perusal of annexure 3, this court is satisfied with the allegation made herein by the petitioner and finds there has been mechanical disposal of a proceeding under section 37(1) of the OCS and PFL Act. In the process interfering in the order at annexure 3, this court set aside the same, but however, for there is requirement of fresh adjudication and disposal of 37(1) proceeding, giving reason. The proceeding consultation revision case number 1817 of 14 is remitted back to the Additional Commissioner Consultation and Settlement Hon'Ble for fresh disposal in accordance with law, giving opportunity to parties concerned and also assigning reason in coming to his own findings by completing such proceeding at least within a period of 3 months of the communication of the order by the petitioner. Free copy of order be handed over to State Council.
Item 31.
Yes, madam. Mike ଟିକେ ଆପଣଙ୍କ level କୁ ନିଅନ୍ତୁ. ଆହୁରି ତଳକୁ କରନ୍ତୁ. Implementation of order in 94.
Earlier order of the board of member board of revenue, my lord, questioning the that right annexure 5, my lord.
How is civil writ maintainable?
My lord, that is not our about the knowledge of the
You
petitioner.
want implementation of a criminal judgment.
My petitioner filed a mutation case, my lord. That is
Mutation which case?
my lord.
এটা
That
কেতে নম্বর কি?
not annexed, my lord.
31, my lord.
The
31.
Right.
31 the implementation of order in OGC number so and so.
My lord, the order passed to approach before the appropriate authority, my
এটা
lord.
কেতে annexure writ petition orderটা কেতে annexure annexure 6.
Annexure 6, man. Page 28, man. Continue page
ও এটা
34.
original jurisdiction
My lord.
না criminal jurisdiction no? Page 29 ଦେଖିଲେ ଲେଖା ହେଇଛି criminal jurisdiction ବୋଲି ও ଏଠି ଭୁଲରେ ଲେଖି ଦେଇଛନ୍ତି.
Again.
Yes, if this order it was challenged any further,
My lord,
this High Court judgment was challenged any further.
no, my lord, I approached before the Tahsildar, my lord. That
ଗୋଟେ SLP order ଆପଣ file କରିଛନ୍ତି. What is that?
the annexure 5 that revision case, state has filed the revision
What
case,
is
my
the
lord.
ultimate direction of the High Court?
To approach before the para 6, my lord. Page 34.
Page 34 रे कौन direction इचे देखले we therefore set
Therefore,
aside
set
the Board of Revenue order.
My lord. And to approach the appropriate authority, my lord, to take action if merited the matter, my lord.
The matter is remanded.
My lord. That
Yes, sir. Why are you not giving a disposal to it?
There is
The
no-
order was set aside.
No pending cases here. No pending cases.
Upon instruction, sir.
No, instruction nahi. No pending cases.
No, Annexure 5 has been set aside.
Annexure
And
5
the matter is remitted to the competent authority. Para 6, page 34.
Yes.
We therefore set aside the order of the Board of Revenue in Annexure 5.
And the present
Keeping in view so and so, we direct authorities to take any action if merited in the matter. So it was a remand matter.
petitioner is not a party.
Petitioner not a party?
No.
Yes, who are you then?
that is the real.
Devasis Chakravarti.
Devasis
You are not a party here. This is a case involving Govinda Chandra Rao.
The Devasis Chakraborty has sold the land for the Govinda Chandra Raut, my lord.
Then
That the
Govinda
real
Chandra
owner.
Aswa Katha court ko.
Real owner, my lord.
Govinda has obtained a judgment in High Court. Why the Vendi will come to High Court?
The apply in the mutation case, my lord. After sold of the land, they apply the mutation case, my lord. That after
No,
mutation.
you have no role here, madam. You have already transferred. Somebody else is fighting the litigation. Judgment is in favor of somebody else. He is not coming to court. No, your attempt will not be entertained. Yes, the read petition, the read petition involved a direction to work out the judgment of this court in Annexure 6. Considering the rival contentions, this court find OJC 9253 of 93, when moved by one Sri Govinda Chandra Rao, present read petition is moved at the instance of Devasis Chakravarti and another fellow, Sri Janathan, and Asim Kumar Chakravarti, as well as Abhishek Chakravarti, who are not party to the writ application. In this circumstance, this court find read at the instance of these petitioners not entertainable. Dismissal of the read petition is not entertainable at the instance of present petitioner doesn't debar the actual petitioner to make an approach to this court, if any.
Item 32.
May I please, Lordship? In action of Revenue Authority, my lord, my demarcation application is pending. Opposite part number 4, annexure 2 is pending.
Demarcation case number achi?
Yes, my lord.
Yes. Annexure 2 demarcation number case achi, like 7/22, pending before Tahsil Attavira, directed to be concluded within a period of 3 months, but however providing opportunity of contest to the parties involved, party likely to be affected. This order is, however, without subject to, there is no stay order operating at the instance of higher forum involving the disputed land. Yeah.
Item 33.
And here, in deviation of the planning authority, in the opinion number 7, encroach upon the common passage road, and there is already physical finding, annexure 2, that he has encroached the road in deviation of the approved plan under annexure 4. But he has not been, the deviation has not been demolished by the town planning authority. In spite of.
All right, then take notice.
Man.
Issue notice on the question of admission, fixing short returnable date, keeping in view the short question involved within. Requisite so and so kar davo by Tuesday. Matter will list as a counter affidavit, if any, by contesting opposite party within a period of 2 weeks of the date of appearance. Liberty granted for listing of the matter. Approaching listing of the matter immediately after completion of reading.
Counter filed by Dhenkanal Improvement Trust.
Yes, four.
ଯିବ notice ସେମାନଙ୍କୁ ଯିବ। ମୁଁ notice accordingly କହିଦଉଛି ସେ ଦେଖିକିରି କରିବେ।
Short date maybe fixed minor.
By Tuesday file the requisites.
Yes, short date हो जे counter तापर
State को ଦେଇଦେବେ copy ଯାହାର notice ଯିବା କଥା requisite file କରିଦେବେ।
Item 34.
I have filed an application before the Tahsildar, my lord, that has been accepted by the Tahsildar and sent to RI to inquire the matter. RI also
Okay,
submitted the report, my lord.
Same issue, Annexure 2 is pending before OP.
Tahsildar Darpan.
Tahsildar Darpana, directed to give a lawful disposal to the request of the petitioner by Annexure 2. Also, ensuring the report as has been asked for on 17/5/23 by completely working it out within a period of 2 months of the date of communication of order. Second case कौन?
Similar.
Same. Sethere भी Annexure 2. Sethere भी direction is for submission of report.
Annexure present case रे Annexure 3 was.
Yes, same.
Present case रे Annexure 3.
खाली देखी दो वो date of report calling ता same अच्छी की नहीं है। Annexure 2 रे indicate is. Free copy of order to State Council.
Item 35.
My lord, petitioner is a 65
RP case disposal, okay, there appears there is long pendency of RP case 1049 of 2004. Almost 20 years have passed in the meantime. This court observes in the events as proceeding is pending before OP number 2, same should be given lawful outcome, working it out at least within a period of 3 months from the date of communication of order, however providing opportunity to party if any likely to be affected. Yes, private party authority.
My lord, petitioner opposite party number 5, 6 going to transport the land.
Please be on mic.
Opposite party number 5, 6, 7 are going to transport the land.
RP case korisaru.
Status ko
status ko dei perini apan padhantu court judgment dei sarlani already. In such contingency, what should be your approach? What should be the approach of the authorities? Apan ne padhu nahanti. Bahar karantu mo judgment bahar kariki niyantu advantage. Yes.
Item 36.
Mayor, please, lordships. Infractious lordships may be permitted to withdraw.
Out of that, yes, Mr. Counsel.
Madam, I am appearing on behalf of open number 1 to 3.
Just 1 minute. Yes, for the pendency of SRP so and so, in the event any sale deed is executed, effect of the sale deed shall remain subject to outcome of the SRP.
Obliged.
Infractious my lord, permitted to it.
Kete?
36.
36.
Infractious my lord, permitted to withdraw.
Withdraw karibe, all right.
Madam, I am for open number 1 to 3.
Rajguru ko na likhi do. Rajguru na Raiguru?
Madam, Raiguru.
Raiguru.
BS Raiguru.
Na likhi do, wala. It are permitted to dismiss as withdraw. This court records appearance of Raiguru, BS Raiguru.
Okay.
Item 37.
My the petitioner prays for that to direct the opposite party number 2 that the repentance of petitioner is pending not to register.
What is the repentation?
The opposite party number 2, that is an annexure 2, page 12, my lord. That is not to allow to anybody.
These representations not maintainable. You may go to civil court jodi apankar asubidha achi.
File a civil suit.
Sorry. Withdraw karibe or dismiss karibe? Yes, petitioner wants to withdraw the writ application in order to avoid civil common law forum available to him. Yes, with this liberty dismissed, but with this liberty, with the above liberty. Yes.
Item 38.
May I please, your lords? Here, my lord, annexure 6 is the notice impung, my lord. But the annexure 6
page kete?
Annexure 6 page, my lord, That's 25, rolling page 25.
So why have you come to High Court?
Because now I am confined to one plot, my lord. 13 assets have been
That's
put to
right. Why
auction.
have you come to High Court? This is just an application. You place your objection.
Yeah, I have filed since, my lord, to 1998, my lord. And to that effect, I want to draw your kind attention, annexure 4 at page 19, my lord.
May I submit minutes to shortcut the things? If plot is put to auction, he says that it is my adjoining plot, I will purchase it, I apply for
He
that.
has to go to civil court to get a declaration.
He doesn't say so. He said that it should be allotted to me because it is a corner plot. But day before yesterday, he served a copy to me. Day before yesterday, he served a copy to me. Over phone, I have taken instruction, no complete instruction.
Let's see matter next Friday.
Yes.
Next Friday. Additional copy they ଦେଇଛନ୍ତି ଆପଣଙ୍କୁ?
I got the copy teacher. Did a copy teacher.
One extra copy be served on Sri Mahapatra who wants to take instruction in the matter. Next listing should indicate name of Mr. Mahapatra. Right. Friday as well, next Friday. Yes.
Item 39.
May I please your lordship? I am in VC, my lord. The present petitioner is the elected ward member of Kolamatia GP, my lord, and challenging the arbitrary action of the opposite party number 2, who has given the work order for construction of the road from Kolamatia Dalitsai to Jorakul Kolamatia Gram Panchayat over the government Gochar land. Your lordship, kindly have a glance my application before the collector.
No, there is no difficulty in considering your representation, but that can't be stay.
Because, my lord, the limited Gochar land is there, my lord. Over the plot, khata number 837, my lord. Already the government has constructed a hospital. Already a village road was has constructed, and
So what is going to be constructed now?
now they have proposed to construct a road from Kalamatia Dalisai to Jorakul Kalamatia Gram Panchayat, man, over the said plot, man, and not deleting the Gochar land from the Khata, my lord, and they are using the Gochar land and for which the villagers.
Therefore, let them consider your representation. But if a public development is taking place for public purpose, why should that be stalled? Agree to why? How are you agreed? Who are you?
Because I am the ward member, elected ward member of the village. Elected ward member of the village.
No, elected ward member has not come to court. You have come as an individual.
Yes, my lord. I am come to individual.
Therefore, individual right is not infringed. Wow. For one man, why should matter be entertained?
Yeah, application is signed by the villagers, my lord.
Application filed by whom?
Signed by the villagers, my lord.
So, are you an applicant?
Yes, my lord.
Where your name appears?
Prabhati Malik, my lord.
Prabhati
Malik.
Could lekhai dekhando?
In the application back page, my lord, the annexure 2.
Oh, kete page 11 re apango naata kuthi achi dekhandu.
1, 2, 3.
ଆଉ ଖୋଜୁଛନ୍ତି କାହିଁକି? ଆପଣ ତ ଦାଗ ରଖିବା କଥା. So you are not an applicant.
Yes, my lord. Already they are.
ଆପଣ ଦେଖଉନାହାନ୍ତି ନାଟା କୋଉଠି ଅଛି?
Because, my lord,
ଆରେ ଏଇଟା 15ଟା ନା ଫାର୍ଷ୍ଟ ପେଜ ରେ 4ଟା ନା ଆପଣଙ୍କ ନା ନାହିଁ.
ସେକେଣ୍ଡ ପେଜ
ରେ 15ଟା ନା ଅଛି ତା ଭିତରେ ଆପଣଙ୍କର ନା ନାହିଁ. ସେକେଣ୍ଡ ପେଜ ରେ ପ୍ରଭାତୀ ମଲ୍ଲିକ କୋଉଠି ଅଛି ମତେ ଦେଖାନ୍ତୁ. ଅଛି. ଆଚ୍ଛା ହେଲା, let us assume you are one of the applicant. 22 ଜଣ application ଦେଲେ, ବର୍ତ୍ତମାନ ଆପଣ ଜଣେ କୋର୍ଟ କୁ ଆସୁଛନ୍ତି. ତାମାନେ 21 ଜଣ ତାଙ୍କ ଆଡେ ଢଳି ଗଲେଣି.
ନାହିଁ ଆଜ୍ଞା, କେବଳ ଗାଁ ଗୋଚର ବୋଲି ମୁଁ
let him consider the grievance, but there will be no stay.
Consider within a stipulated.
ଯଦି construction ଆରମ୍ଭ ହେଇଯାଇଛି, construction continue କରିବ.
Then no construction, man.
ठीक है, all right. I am observing. If construction has already commenced, then there shall be no stay. Krishna has a serious allegation and submit on the illegal construction involved herein. Taking this court to annexure 2 series, counsel for the petitioner submits. The petitioner herein, along with several others, have already registered the construction involved herein. And their resistance, they have already registered their protest by Danister 2 series pending consideration of the collector Jaspur. It is alleged in spite of submission of such representation through registered post. Since 4/5/23, there is no outcome on it. And there is illegal attempt of going ahead with the construction. This court records statement of the learned counsel for prisoner that there has been no commencement of construction as of now. Considering grievance of prisoner pending with competent authority, OP number so and so, Collector Jaspur.
OP number 2, ma'am.
2.
Yes,
Two.
ma'am. Yes,
OP
ma'am.
number 2. This court, while directing the collector OP number 2 to give a lawful disposal to the grievance of the petitioners by Danister 2, to see there is no commencement of the construction involved herein, provided the construction already commenced by this time. And the outcome to the Danister 2 be given within 2 weeks of the communication of the order.
Published, ma'am.
Item 40.
My lord. My lord, in this case, the petitioner is seeking for a direction for expeditious disposal of demarcation case number.
A demarcation case, giving opportunity 3 months. Provided there is no lawful obstruction in undertaking such exercise.
Item 41.
Through common law forum or in the entertainment of any other writ application. Yes.
Item 41.
Yes, it appears there is long pendency of consultation appeal 10 of 14. Considering there is already sufficient delay in disposal of such appeals, this court direct the OP number 3 for disposal of the expeditious disposal of the consultation appeal 10 of 14, preferably within a period of 3 months from the date of communication, but however, in the involvement of party likely to be affected. Yes.
Item 42.
42 may I produce? Well, this is second contempt petition, my lord.
First contempt.
My lord.
First contempt.
Second, my lord.
Second.
My lord.
First contempt directed. बहुत आसुची आजकली आ गोटे मास देई दोची जदि न करिवे ताले टोमोटो कंटेम्प्ट हो
My lord.
हला सेकंड कंटेम्प्ट रो ऑर्डर कर दो यस
Item 43.
Non-compliance of the order dated 2012.
First contempt.
My lord.
First contempt.
Yes.
Item 44.
44, my lord. It's a first contempt.
Eta kon hearing abo?
No, my lord. Because your lordship was pleased to direct the registry to list it along with WPC number 1224 of 2020.
Assi aji assi ta sangare.
Na 8224.
8224 of 23.
23. Se file ta asli. In my
assi
na.
One pay magayitla se file.
In this case, in the writ petition, my prayer was for a direction to the Tahsildar to take necessary action in proportions to the letter given by the additional commissioner endowments.
That was a division bench order.
No, single. Your lordship's order. Your lordship's
in 8224.
No, in my case.
Or in the other writ petition.
1004.
Eta 1004.
My lord.
One direction itla.
The direction was to the Tahsildar Bori, considering the innocence prayer in disposal of the writ petition, this court observes. In the event there is no challenge to the direction in Annex 6, the Tahsildar Bori is directed to work out the same by giving effect at least within a period of 2 months from the date of communication of the order.
If Annex 6 is a challenge to the in the other writ.
No,
yes.
no. That was not the challenge.
Why that file was called for?
Because, my lord, in a complaints report, my lord senior submitted a report from the Tahsildar that since the case that is pending before the Honorable Division Bench, so it is not, we cannot comply the order passed by your lordship.
Therefore, wait till disposal of the
Because
division bench.
that case, your lordship kindly see the prayer in that case before the Honorable Division Bench. And the order passed by the Honorable Division Bench.
Yes, if that land involved there,
Land involved there.
then the contempt will not lie.
No.
You have to wait. I can request the division bench for early disposal. Yes, undisputedly, land involved in the writ petition number
1004.
1004 of 23, also involved in WPC 8224 of 2023. Pendency of the WPC 8224 of 2023, creating embargo in implementation of direction in WPC 1004 of 23. In this situation, while observing no contempt petition will lie at this stage, this court requests the division bench, appropriate division bench, for expediting the disposal of WPC 8224 of 2023. The order of this court be communicated by registry to the assigned division bench for their appropriate consideration and direction. Yes.
Your Lordship, there is a second sub-item. There is a second sub-item.
Sub-item kon air sange link?
Asichi, but then in those cases, the learned additional assistant commissioner is not a party in any of the writ applications.
May not be, but Jadi.
No direction also to him also. Direction is to the Tahsildar.
Land might be involved.
But they have filed contempt against me.
Contempt is filed, no, madam.
I learned
Contempt is filed because of your lordship's order direction. Nowhere it is directed that to correct the ROR. But directly the Endowment Commissioner has written a letter to the Tahsildar Bari that paragraph 5 of the petition says so and so, and you have to carry out.
No.
No link to this case?
No, my lord. No, my lord. My lord may kindly see.
Okay, then let us see what was the direction.
Yes, my lord. My lord may kindly see Annexure 1.
Yes, come to page 9.
My lord, page 9. My lord, in this paragraph 5 says, directed in above view of the matter, this court, while declining to entertain the writ petition at this stage, keeping the matter for consideration of the Tahsildar, but however, considering the submission of the learned counsel for the petitioner, that the petitioner is not even a party to the proceeding by the Annexure 2, this court observes, in the event the proceeding involving the notice at Annexure 2 is still under adjudication, it will be open to the petitioner to file his objection.
So you ଆପଣଙ୍କୁ ସେଥିରେ ପାର୍ଟି ହବା ପାଇଁ ସୁଯୋଗ ଦିଆହେଲା।
ଆଜ୍ଞା ଆମକୁ କହିଲା ଯେ ଆମ କଥା ଶୁଣିବା ପାଇଁ ସେଥିରେ କହିଲେ ଯାହା କିନ୍ତୁ ୟା ଦେହରେ କୋଉଠି ଆପଣଙ୍କର ଡାଇରେକ୍ସନରେ ନାହିଁ ଯେ ROR କରେକ୍ସନ କର କିନ୍ତୁ
କୋଉଠି ଦିଆହେଲା ସିଏ କୋଉଠି କହିଲେ ROR କରେକ୍ସନ
ଚିଠିରେ କହିଛନ୍ତି ସେ ଚିଠିରେ ଏଇ ଯୋଉ Annexure 3 ରେ ତାଙ୍କ ଚିଠିରେ ସେ ଟୋଟାଲ ପେଜ 20
ତାରିଖ ଅର୍ଡର
ପେଜ 20
page 12 କେତେ ତାରିଖ
ଅର୍ଡର 20 ରେ Annexure 3 ରେ ସେ ଏଠି ରଖିଛନ୍ତି ଚିଠିରେ କାହାକୁ ତହସିଲଦାର ବରି ପାଖକୁ ତା ଦେହରେ ଲେଖିଛନ୍ତି ଯେ ଡାଇରେକ୍ସନ କଲେ ହାଇକୋର୍ଟ ତମେ ଏଟାକୁ ROR ଟାକୁ କରେକ୍ସନ କର ପୁରାପୁରି ଡାଇରେକ୍ଟ paragraph 5 ଲେଖିଛନ୍ତି ଡାଇରେକ୍ଟ paragraph second paragraph it is pertinent to mention here that by order number 1 dated 22/8/2022 passed by this honorable court in WPC number 19,821.
Then he should recall this order. He should recall this. I have never directed in such.
No, man. Nowhere it is directed.
If Annexure 2 is still pending, then his participation will be permitted. That's all. So, कौन करिए? मैं आपको next week नेबी आपको recall करिए. Recall कर दो. ये किए assistant and additional assistant commissioner. A serious allegation.
Completely different para direction गोटे type रो चिट्ठी है ची गोटे type रो जितम करे कोडी paragraph 5 रो
that there has been misreading and distraction.
Simply adjourn, I'll file a
misreading as a consequence wrong direction given by Annexure 3 being issued by additional assistant commissioner of endowment. this court on perusal of the ultimate direction of this court in the disposal of WPC in the disposal of WPC 1981 of 22. Prima facie appears there is wrong direction by annexure 3. Ms. Naidu appearing for the additional Assistant Commissioner of Endowment seeks 1 week time to take instruction. Copy
No.
दे दीजिए
Yeah, copy receipt, but it was
पढ़ी
served late.
Yes, the matter on Monday next कर दियो.
My lord.
17 तारीख रहे.
Oblige your lordship.
Yes, in all probability, you will submit next day that you have recalled this order.
Yes, lordship said. That is the challenged in the writ application as well, in before the division.
Then
Item 45.
the judicial officer time the poor understanding कौन होती? He is a judicial officer.
Yes, lordship. I'll verify the.
My lord, it is a Gyanondal case where my, yes, my lord. Past contempt, yes, my lord. I think
In the meantime, they have already submitted their
copies of the books.
But the problem is, my lord, they have not submitted their expenditure. What is the total expenditure?
So have you communicated them?
Yes, yes. We have already communicated. Let them submit the entire expenditure.
2 weeks after or 3 weeks after. In the meantime, you communicate them.
সেটা দিয়ে দিলে টাকাটা রিলিজ হয়ে যাও কিছু না
Place the matter 3 weeks after date कर दो. In the meantime, this court hope and expects the issue involved will be sorted out
Oblige.
in the cooperation of the petitioner.
Oh, yes, my lord. I oblige.
Yes, no.
My lord, date mein.
Item 46.
Date 5 order a date.
Item 46, I mean, VC, my lord, this is a case
Item
with
46.
regard, this is the case with regard to having Jagannath temple disabled friendly, my lord, having access for the disabled friendly persons, my lord. This is the case with regard to having Jagannath temple Puri disabled friendly, my lord, so that the disabled persons can go up to the deities, my lord, for worshipping. The writ petition was disposed of, first contempt was disposed of on 20th of December 2022.
This order has not been worked out.
Not yet, my lord, not yet, my lord. My instructions were about a month back. So there was a meeting of the chief secretary and other officials, and this petitioner was called there, and they were saying that they are facing difficulties in getting this order executed, my lord. That is my instruction.
काहा को direction नहीं तला?
It is the managing committee, my lord.
OP 234 को direction नहीं तला.
And the collector Puri, my lord.
Issue notice directing the contenders to file response within 1 week of the service of notice. Requisites as undertaken
By Monday, my lord.
Monday.
Let a
Place
date
the
be
matter.
given. Let a date be given, my lord.
Place the matter after the pleadings completed.
Oblige.
ऐसे करूचन, there is some progress, there has been some
No,
satisfaction.
actually, honestly,
Old
କିଛି ହେଇନି
people,
actually.
ଶୁଣନ୍ତୁ ଆପଣ ଯଦି ଭାବିବେ
ଆଜ୍ଞା।
ଯେ ଦିନରେ 100ଟା wheel chair ରହିବ 100 ଜଣଙ୍କୁ facilitate, that
ସେଇଟା
will
ଆମର
not be
ନା ସେଇଟା
possible.
that was never a prayer. It should be made disabled friendly. It
But
can
in
be.
the meantime, they are cooperating. Some senior citizens have been taken by wheelchair.
ନାଇଁ ମାଲ wheelchair का
I don't know how the allegation subsists.
No, because
ଏଇଟା ସେମିତି ସାମାନ୍ୟ ମନ୍ଦିର ନୁହେଁ।
it's a big temple.
ଦିନକୁ 1000 ସିନିୟର ସିଟିଜେନ ଆସିବେ ଆଉ ମନ୍ଦିର ବାଲା 1000ଟା ଷ୍ଟ୍ରେଚର ଧରିକି ବସିଥିବେ।
ସେଇଟା
ଦର୍ଶନ କରିକି ଆଣିବେ।
That is not possible.
Come, let us see, there is some development in the meantime.
Item 47.
My lord, item 47, my lord, first contempt, non-compliance of order dated 10/5/2023, passed by your lordship.
ଲେଖ, this court hope and trust by the next date of posting, there shall be arrangement for removing the inconvenience faced by the senior citizens or the handicapped people in having their offering to the Lord Jagannath. Visiting and offering to the Lord Jagannath.
Grateful.
All right. Yes,
Obliged.
I've given some indication, so.
Yes, I got it, my lord. Obliged.
Item 47,
Item 47, my lord, first content. Non-compliance of order dated
First
10/5.
contempt.
My lord,
Close.
first by your lordship, man.
अच्छा ये company act proceeding में why so much names are coming?
se print ରହିଛି ଆଗରୁ ସେ ଆସିବ।
No, first order करो लेखा rest is directed to take out the names. As it is, there is unnecessary reflection of so many names when many of the advocates have already completed their responsibilities and even there has been disposal of many applications of such counsels. Next listing will only indicate and there has been also a lot of progress. Now the matter is only pending in the involvement of the registrar of company, state council, and the PF authority. There may be reflection of names of other councils provided there is any other miscase pending involving such councils. 200 ना लिखा हो
आगे आगे हम देखिए लिस्ट है एंटायर लिस्ट
सब क्लोज ही गलानी
हाँ,
जहाँ जहाँ
जाने।
इशू सब क्लोज ही गलानी. Yes, now
See, I am pardon to mention, Lordship. I am pardon to mention. I have 1 of 23.
I am not in list today.
For next sitting, 1 of 23.
Let it be listed, thereafter we'll see.
Listed.
Now it's not there.
आदि नहीं
Is it there in the board?
No, Lordship.
अतल काई mention
For that I am
one सब matter नहीं करेंगे.
That is a
और जो issue ऊपर अच्छी मु आगे ताको decide.
my issue is coming here, Lordship, otherwise. Not
You may
secret.
file memo. You may file memo for listing your memo. In this case.
your lordship.
Yes, today, yes. What is the
Yes, my lord.
development? Mr. Das, you wait for a while.
Lordship, I had filed a report on last occasion and it was adjourned for a week, Lordship, and we have made significant
Please
development.
get the mic little closer.
Lordship, so sorry. Lordship, last occasion we have filed a report, the Office of Official Curator, and afterwards we have made a significant development also, Lordship. Till date, means till yesterday, Lordship, we have paid off to 3560 number of work.
Just give a copy of that.
Lordship, it is only.
You have additional copy?
It is handwritten, Lordship, if my Lord would like to.
Any difficulty? You want indulgence of the court?
No, Lordship, till date we have not facing any difficulty. Only 50 to 60 odd applications are pending, which will be disposed by next week or by Monday, Lordship. So as and when they are coming, we have been paying the workmen. PF is paid from our side, Lordship. We have started payment of unsecured creditors also, Lordship. So by next week, we'll be able to complete all the pending payments, Lordship.
No, you are mentioning you have paid interim dividend at the rate 7,000 to 3109.
Lordship.
And at the same time, you also indicate by 6/7.
Lordship.
You have already released the dividend in favor of the 3560.
60, Lordship. Lordship, because
So that also includes the interim dividend.
Yes, Lordship. For 3109, that has been
So
deducted, Lordship.
3560 is closed now.
Yeah, 3560. No, Lordship, exactly total number is approximately 4495. So out of
4495.
Lordship, out of those approximately 930 approximately they are remaining to be paid because we have already issued a dividend, but it is not coming back. As and when it is coming back, we have kept a 1 month window, Lordship. And if they're coming back within that window, then we'll be paying.
The money will be deposited with the central government.
Lordship, that is the option.
So we gave them one more term.
Lordship,
one
Lordship,
time.
Lordship. At least a month of time is to be given to them.
So 932 remaining.
Lordship.
Okay, had the submission of the landed company registrar, the official liquidator herein, who brings to the notice of the court, company court, that out of 4495 workmen entitled to dividend identified in the meantime.
Lordship.
There is disbursement of dividend in favor of 3560 number of workmen, amounting 89 crores, 22 lakhs, 57,126. The remaining 922 workmen, in spite of notice, are not coming back.
Lordship, 50, 60 odd we have received, Lordship. 50 to 60 applications we have received back.
Only 50.
50 to 60, that is what we spent.
50 have responded.
Approximately 50, my lord.
Approximately, however, out of this 932, roughly 50 odd people have already responded, and their case is under active consideration.
Lordship, by Monday we will complete. Lord.
Balance people, there is difficulty in releasing the development in the dividend for their non-cooperation, and even after sufficiency of notice.
Sufficient time has been given, Lordship.
In this situation, the official liquidator requests this court for at least granting 1 month more time as wait period
Lordship.
to entertain claim by these 800 and odd people.
Lordship.
932 to 50 chhadi diyo. 800 and odd calculation kari kardo. Ye gale au 18 ta jibo 882.
Lordship.
This court find there is a reasonable request by the official liquidator, and dividend since already worked out, and identification at the side of the official liquidator since completed.
Lordship.
The beneficiaries should be given one more opportunity.
Lordship.
In the process, this court extend grant the extension for receiving application through the 882 rest workmen involved herein. If submitted, to be entertained if submitted within 1 month hence. This court also makes it clear in the event there is still no response from the the persons entitled to such dividend, it may be open to it shall be open to the official liquidator to find the actual surplus
Lordship.
on account of dividend and place the surplus amount in the treasury of the Government of India.
Lordship.
With a rider. Claim application, if any, comes after such cut-off date, shall be made to the competent authority under the Government of India.
Lordship, there is one.
And shall also be in the Department of Company.
Ministry of Corporate Affairs, Lordship.
Ministry of Corporate Affairs.
Lordship, there is one rider to it, Lordship. There is one rider. I'm sorry to intervene, Lordship. The rider is like the shareholders are also required to be paid, Lordship. If the money is remaining with
that
us,
I'm coming.
Lordship.
That I'm
Lordship.
Let us close this issue. Okay. Applications are to be made. No further application will be entertained here, nor at the side of official liquidator. Application, if any, shall only be entertained at the end of the Government of India Corporate Affairs, Department of Corporate Affairs,
Ministry
and
of
decided there also. So that is one part. What else you are submitting?
Lordship, if the money is remaining with us, then as per law, we have to pay it to shareholders also. So Lordship.
There is some amount?
Yes, Lordship. It is sufficient amount is there, Lordship. So we may announce a
Then
dividend.
is any application pending at
No,
the
Lordship, for
extension?
that I'll have to publish a notice in the newspaper, Lordship, that we have
Okay.
surplus. So
Okay.
by 15 days time, I require to do all the formalities.
So,
Lordship.
issue the notice.
Lordship.
Or make the publication.
Lordship, I have to do some calculations. I need to take help of a chartered
Okay.
accountant,
It has
Lordship.
been brought to the notice of the company court that there has been some share outstanding towards the shareholders.
Lordship.
However, there is no claim application as
No,
of
Lordship.
now.
No, as of now.
As duty bound, the official liquidator wants an advertisement
Lordship.
for information of all concerned,
Lordship.
inviting such applications. This court permit the official liquidator to go ahead
Lordship.
with appropriate publication
Lordship.
in one local newspaper simultaneously also in two of the national Delhi,
Lordship,
widely circulated in the country.
Lordship,
But there is a problem.
Lordship,
Now these national Delhis are also being published area-wise.
Lordship,
Odisha has a illustrated weekly or Statesman or Indian Express.
yes, Lordship,
So you request the publishers
Lordship,
to publish it in all their circulations.
Pan India, Lordship.
Okay,
Lordship.
so that if 22 papers are coming out in a day of a publication,
Lordship.
all 22 papers should carry that article.
Lordship, I'll take care, Lordship.
Others, some people staying in Bombay, he may not be knowing publication.
There's a
in
possibility,
Odisha.
Lordship, yes. I'll take care of this, Lordship.
Yes.
And I need a help
The
of
necessary advertisement may be brought within a period of 3 weeks.
3 weeks, Lordship. And before that, I request Honorable Court to grant me permission to take help of a chartered accountant also, Lordship. Chartered accountant. Because we have to
Yes,
calculate,
yes,
Lordship.
The formal actions through any other agency is
Lord.
also permitted. For the purpose is also permitted.
Lordship,
to be
obliged.
Undertaken in the meantime.
Lordship.
So that's an.
This issue is.
Yes, Mr. Now the
Obliged.
PF issue is there. Yes,
Lordship.
what are you submitting?
My lord, your lordship on
Please, please
21
on
4
mic.
2023.
Please be on mic.
Yes, my lord. Earlier, my learned senior advocate Mr. S.K. Patnaik was appearing on 21st of April 2023. Your lordship passed an order. Your lordship may kindly see.
What
order
is the date of order?
21/4/2023.
Yes, 21/4 IA 5 of 23.
There were 3 orders, my lord. Order number, I am referring to order number 296.
296.
296.
It's a general order.
Yes, my lord.
Yes, please read.
About 7 lines from the top.
No,
This
read the paragraph.
This paragraph number 2,
Yes.
about 8 lines from the top. This
please
court
read
also
the
requires.
paragraph, whole paragraph.
Whole paragraph.
Whole
My-
paragraph.
So far as the release of the dividend in favor of the beneficiary is concerned, this court finds, as per the available beneficiaries, a list of 4,495 number of beneficiaries has already been prepared, and there has already been identification in respect of 3,317 number of workmen. And in the meantime, there is also consequential release in favor of 2,584 number of workmen. It also appears a total amount of rupees 69 crore 79 lakh 62,856 has already been distributed by the official liquidator to 2,584 number of workmen. This court also records the submission of the official liquidator that the official liquidator is still working in respect of the balance employees, since the Regional Provident Fund Commissioner 1 BBSR has already handed over the identified workers list around 4,000 just yesterday. The official liquidator is granted 1 month time to finalize identification process and take steps as appropriate for release of the dividends in favor of the balance unidentified employees as of now.
So this
It
is
al-
all a direction to the official.
My lord, my lord. Thereafter, it is also directed that in the event any further identification is achieved.
It's all
yes,
regarding
yes, my
release
lord.
of the dividend.
My submission is, my
And
lord.
including the identification issue.
Yes, my lord. My submission is, in terms of your lordship direction, thereafter your lordship director filed an affidavit. We have filed an affidavit. A document has been enclosed to that affidavit. Affidavit was filed on 23rd of June 2000.
Give a copy. Where do we find this with a?
Only 254, about 254.
What a copy ଦିଅନ୍ତୁ ଆଉ ଗୋଟେ। ଏତେ ବଡ brief ରେ ମୁଁ କୋଉଠି ଖୋଜିବି ସେ affidavit କୋଉଠି ଅଛି? କେତେ ତାରିଖର affidavit? 8/10.
23/6/2023 I filed. 23rd of June I filed. Your lordship may see this one.
You give a copy better.
There I have enclosed
But
one.
this order nowhere said filing the affidavit.
No, 295 order affidavit kotha achi. Order number 295.
295.
Yes, my lord.
So let us see that order.
Yes,
What
yes,
was
yes,
the
my lord.
direction?
Let me place that 295 order. Order number 295.
Yes, come to order para 3.
Para 3. Yes, my lord. Yes, my lord. For the clear disclosure through Annexure B, Mr. Sekhar, official liquidator present here, has no
Where are you reading? Where are you?
direction is, my lord, towards the end.
Para 3 ରୁ ପଢନ୍ତୁ। Okay, para 2 ରୁ ପଢୁଛନ୍ତି।
para 3 I was reading, para 2 I was reading.
Okay, all right, read it.
For the clear disclosure through Annexure B, Mr. Shekhar, official liquidator present here, has no hesitation in handing over the amount to the Regional Provident Fund organization by way of check within
that's
2
a-
hands. Considering that this is not that important, my lord. Your lordship may kindly come to that towards the last portion. Sixth
So I
line from the
directed
bottom.
there to regularize the account of the account holder.
Yes, my lord, and that,
Then I have also given further direction for releasing their contribution.
my lord, indemnity bond, your lordship has said.
Except the pension amount retention. So what is your difficulty now?
Difficulty to that document enclosed to the affidavit, the document enclosed to the affidavit, your lordship may, for a moment, your lordship may see, about 254 number of, that is, we are facing
Not
difficulty.
traceable.
We are facing difficulties because their names, father's name, date of birth, nothing
You
is.
can ask them for clarification. So I may grant some time to you.
No, your lordship may grant us some time unless and until we get their addresses also.
254.
That document is there.
254.
My lord, my lord, my lord, my lord.
Annexure D.
Yes, my lord.
So I grant you some more time.
That
Are these people available?
we are not in a position to know about those persons.
Then you may
That
go
is the
for a paper
problem.
publication.
Sorry, my lord.
You may go for a paper publication.
That is the only.
You can't. It
Yes,
is
yes,
their
I
money.
understand. I understand, my lord. That is the
You can't
only.
retain that money.
That is the, no, we cannot retain that.
No.
No, not permissible.
Retention is permissible only to the extent of pension contribution.
My lord, my lord.
That you may say. Again, if nobody is available, then you go for
Paper
a
publication.
wide circulation.
That will do.
If you
That will
get
do.
somebody, it is well and good, or else you place this amount involving these 254 with the central government.
My lord, my lord.
At the submission of Sri Bimbisar Das, the senior counsel on behalf of the Provident Fund Commission. In the replacement of Sri Patnaik, S.K. Patnaik earlier appearing. Sri Das brings to the notice of the court an affidavit of the additional affidavit of Regional Provident Fund Commissioner rated. You have given a copy to the.
Already
I've been
by
supplied.
mail, by
I've
mail
been
already.
I've been supplied, Lordship.
It is affidavit dated 23/6/23.
Yes, ma'am.
23/6/23. Revealing in para 1 and 3 as follows. In reference to the aforesaid amendments, Sri Das contends, and further in reference to the communication of the RPFC to the official liquidator by Annexure D, Sri Das brings to the notice of the court that their office has already generated 3934 numbers of UAN out of 4188 identified beneficiaries. With regard to balance 254, there is no trace in respect of different aspects of such persons. There is request on behalf of Provident Fund Commissioner for grant of further time to at least attempt to find such trace through the beneficiaries. Okay, considering a genuine request involved herein, while also keeping in view that the amount lying with the Provident Fund Authority belongs to the beneficiaries, and there can't be detention of such amount for long with the Provident Fund Authority. Let the Regional Provident Fund Commissioner too endeavor to reach to these unidentified, the 254 members in respect of whom there is difficulty in generating the UAN. Even attempting through wide circulation in newspaper. Vastly circulated newspaper. Providing opportunity to such persons to remedy out the difficulties at the end of the Provident Fund Commissioner. For the above purpose, this court grant the Regional Provident Fund Commissioner to at least 6 weeks time. 6 weeks time I am granting. 6 weeks time. Hello. So you have probably no other issue except
This is the issue, Lordship, which we have, my Lord has already addressed.
1 month time extension is there. So let
Lordship.
us bring it after 6 weeks.
Lordship, no, Lordship, at least for my purpose, 3 weeks time, it has to be.
6 weeks.
No, not for your purpose. I'm just talking about learned counsel. It is not your case, sir. For my purpose, because I have to come with a
We
report.
are giving 1 month time at least to the beneficiaries.
That is a separate issue, Lordship, but for the publication of newspaper with regard to shareholders and the calculation by the chartered accountant. By 3 weeks, I'll submit a report,
In
Lordship.
3 weeks, let there be a report on the further development at the on the working out at the end of the official liquidator, at least within 3 weeks.
Published. All processes are
4
mixed,
weeks
Lordship.
ପରେ ଆସୁ ଆପଣଙ୍କର କ'ଣ development ହେଇଛି ବି କିଛି
ଜଣେଇବୁ।
matter will be listed after 4 weeks.
Lordship,
I have
5th week ରେ କରିବ so that ଆମେ ଏଇ ଯୋଉ 4 weeks ର difficulty will be passing over. We can close the matter so far as official liquidator is concerned.
I have also filed one IA 7 of 2023.
Forward.
Sent a copy to the official liquidator by mail also.
What is that IA? What a copy out of the that is in the list today.
That is in the list today. Your
Flag
Lordship,
11.
Your Lordship, in
Yes,
order
copy.
number 295, dated 21/4/2023, has observed in last portion of para 1, the contribution towards PF dues at the end of official liquidator at rupees 20 crores 30 lakhs 45,640 stands confirmed. And there should not be any controversy thereafter on this issue with the official liquidator. This pertains to 7Q. In 7Q, my lord. Interest part.
That you are
Lordship,
forgo.
no,
This
Lordship,
cannot be
Lordship.
collected.
No,
now.
Lordship, learned counsel is not putting a right hand on the right
While you
issue.
bring an objection here.
Lordship, already I have adjudicated the claim. After adjudication, I have given the dividend. Now they're asking about interest.
Give a objection.
Okay, Lordship.
Give a objection to this application. So that I
But
pass
that is
order.
not, Lordship, in that I may like to see, my lord may like to see. It is not clear that the amount is related to 30Q or what
7Q.
7Q, what sir is saying. It has already been rejected. And
that
this,
reply.
okay, fine, Lordship.
Give that reply.
Then
so
the
that
matter
I
may place,
record that and
Lordship,
resolve the issue.
matter may be placed by 3 weeks,
They
Lordship.
can't
because-
go on claiming they were
Lordship.
sleeping.
Lordship.
Who will now get this money?
Lordship, definitely I'm going to
If they
respond
would
to-
have put
give
forth
response
their
to them.
claim,
Lordship.
we would have raised the sale price accordingly.
This issue was already raised, Lordship, before my lord only.
Oh, that is-
And it was
therefore-
already addressed, Lordship. I'll
therefore
bring it
bring
on
that
record,
to
Lordship.
the- in your response.
Lordship.
This was earlier raised.
Lordship, I cannot relook my own orders, Lordship. No, I have already adjudicated the claim. How can I relook my own orders?
That's right.
Lordship.
Okay, let there be. There is some issue involving IA number 7 of 23. The application needs a response from the official liquidator.
Lordship.
2 weeks time at least.
Lordship, 2 weeks, I'll be.
Let an objection to this application be filed within 2 weeks. With service of copy of the same on the RPFC 2. Response, if any, to such objection be also brought within 1 week thereafter.
Lordship.
ହେଲା ଆମେ ତ 4 weeks after ଆଣୁଛେ ଦେଖିବା ସେଦିନ decide କରିବା.
My lord, can I take back that one? Make a photocopy once again, I'll give it. Because I have got a single
Since the brief has gone,
I understood. Henceforward, whatever.
difficult to trace those people.
Yes, yes.
And I am to keep a man standing here. Affidavit ଟା ତ ଦରକାର ନାହିଁ, petition ଟା ଦରକାର ଅଛି.
I'll make a photocopy once again, I'll give it to your lordship.
ମୁଁ ତ କୋଉଠି ଗୋଟେ କେଞ୍ଚି ଦେଲିଣି.
Related to handing over possession, my lord.
No application is now on board.
My lord, that is there. IN number 7 of 2022.
Where it is there, this? Where it is there? in the
Item number
list?
49, my lord. Item number 49.
49,
My
next matter.
My lord.
Okay, all right.
Related to
Item 49.
49.
My lord, in this IA, we have filed. and-
49, they say they have handed over. You
No, my
say
lord.
it is not
Only that
handed
is-
over. So let
They-
it lie over.
No, no, they
Let it
have,
lie over. This court has no time to hear such matter.
my lord, they have filed a
Let it
response
rest
where they have admitted. Well, lordship,
Sometime in October.
well, lordship, kindly bear with them for a
Please,
minute.
please, I don't have time.
Well, they have filed a response where they have
All right,
admitted.
some court will hear and pass order. I don't hear this matter. Yes.
Item
next.
50.
50. Yes, 50 is the CMAPL. Who is there? Nobody is pressing this application, stand dismissed for non-prosecution.
I may pardon, my lord. Item number 50.
Item 51.
Item number 50, my lord. I may
50,
pardon.
you are there, nobody is responding.
I apologize. I apologize.
It's the
my lord.
CMAPL.
Yes, my lord.
Who is for OPI?
My lord.
There is somebody else, Satyavrata Mahanti, copy ଦେଇଛନ୍ତି ତାଙ୍କୁ? Copy ଦିଅନ୍ତୁ ତାଙ୍କୁ.
My lord, I'll provide a copy.
All right, ନହେଲେ notice କରିଦିଅ CMAPL ହେଲା. Issue notice in the limitation ଅଛି ନା, ତମେ notice କରିଦିଅ. Along with copy of the CMAPL.
My lord.
Requisites as undertaken by Monday.
My lord.
Yes, 51.
Item 51.
Sorry, vacation of stay I am not entertaining.
I have filed a miscase for vacation of interest.
I am not entertaining. Once interim order is there, it must continue till final hearing.
My lord, the shop is some miscreants are
Sorry.
using the shop room.
Sorry.
Now the shop room is in the damaged condition.
Miscase lekhiwala. It's an application for vacation of stay.
Already-
The opinion of this court, once there is consideration on the interim aspect and an interim order is passed while entertaining matter, the interim order should continue till final outcome. Yes, petitioner, the counsel for the OP, if so agree, may renew his prayer for expediting the hearing of the proceeding after 6 months. Interim order to continue. Yes, intervention petition list
Because intervention petition may not be necessary. Intervention petition may not be necessary because I have come challenging the revision order and pendency of the interim application not considered. And it is a property dispute under consolidation of holding and prevention of property. It is a proceeding under 37. And that is what minors passed in interim order. Now, in the meanwhile, revision of the court has functioned. Now the revision
proceeding will be.
Yes, that can be also done.
So you came under a particular contingency. The
Yes,
regional court was
yes.
not operating.
Yes, ma'am.
Paragraph 11 of the. So let us dispose the matter.
Yes.
In fact, on 7th November, they have sold the land to me. December.
Subsequent.
Be considered there.
Let
I'm not taking a decision, Mr. Das.
let me be added so that I can also participate. It
How
can
can you be added
Go
here?
there, you go there, make an application. Why you will take a leave from High Court?
Because after selling it, how he could maintain.
That you can raise point there only.
Or else Jolly will sit at your home. You have already sold.
No,
Jolly
no,
will
no,
sit
no.
at your-
Sold by my lord, he has sold to me.
Okay, that's not the issue here.
Exactly.
That's not the issue. Therefore, if you want to be intervened, I am disposing the matter. You can file application, see further course of action.
One thing can I, my lord? Your lord,
Why unnecessary issue?
only my presence at least, so that it will help me there, or else
what
it
is
may
that?
difficult for me, because your lordship knows, my lord.
My lord, wanted a straw.
Wanted to know why you have sold and filing writ.
That is the point we decided.
Suryakanta Das for the intervener. Hello. Considering the submission made herein, this court find the writ petition was brought under special contingency in the non-functioning of the revisional court.
Revisional court.
Creating an impediment in the.
To move the interim application.
Sorry, embargo on the revision petitioner in the attempt of the opposite parties there on implementation of the appeal order. This writ petition was also entertained on the specific contingency of revisional authority not available for the purpose. There is submission, there is no dispute in bar that the revisional authority has already commenced functioning. In the process, this court finds the writ petition is no further entertainable. Revision number?
ଦୁଇଶହ ଆଠ of 2022
Revision 214.
214 ଗୋଟେ 208 ଗୋଟେ ଦିଟା କେସ୍ ଅଛି
214 and 208 relegated back to the revisional authority for its final outcome, giving opportunity to the parties concerned.
interim order minors protected me interim orders. That order may
Now you know the
Biswanath Agrawal case minors referred to. Now what is happening, minors may I submit one thing, minors. So for appeal is concerned, minors always holds good, minors government is respecting and government authorities are respecting.
interim order passed.
The interim order after selling is against me.
Well, so target
Revisions are also directed to be disposed of within a period of 3 months of the appearance of.
My only small prayer allowing me to intervene so that
You apply there.
because after selling he is maintaining the stay order against me, my
You
lord.
apply there.
If you will, I will succeed, you will succeed.
Your lordship
Yes,
will
next,
direct
next.
the parties to produce the copy of your lordship's order before the revisional court, your lordship's order may be produced and he may act.
Yes, definitely. On production of the copy of order of this court, the revisional proceeding will be immediately commenced.
53 minors.
Whatever the law.
Minors 53 a peculiar thing has happened, minors.
Just 1 minute. Auri to gude case achi after recess possible.
53
connected ta kon?
Same, two revision.
Sei pe dita number dela pura dita ko gote order re kar dio. Dita revision involved achi. The rest of the cases after
54 minor permitted to withdraw. 54. Next time.
batch kon thila withdraw.
Permitted to withdraw.
54 ta withdraw kar dio. Acha 53 re se amu kahi parvise comment deichan.
53 parvise comment has been
registry is directed 53 re registry is directed to take out the parvise comment of OP number 3 and hand it over to the state council who will be presenting himself before the registrar judicial for the purpose on Tuesday. Upon Tuesday gale se taku copy dei dabo. Counter if any be filed within 2 weeks. Interim order achi ki?
But interim order is the very peculiarity is that my license has been stopped because I am suffering.
The counter ta asu.
Kindly that now paravise has come. The paravise will be with minors, my London friend.
2 weeks they deli counter pai.
Counter to already minors have granted 3 weeks time. What they have done is they directly send it to the registry.
I said a counter hella ni na.
Counter so
counter pai 2 weeks.
Very short time because I'm suffering every day. I'm losing minors.
Okay, all right.
I'm unable to run the unit minors.
Third week पर ଗୋଟେ date कर दियो Friday रे आसीबो जो Friday मु 5-7 matter नउची सेही इथरे list हो ये third Friday और fourth Friday देखो कोथरे सेटा adjust हो कर दियो एटा भी batch टा सरी गला 55 onwards I will be taking
55 तो सरी गला
देखो एटा सरी गला 55 25 रे जा order is se order hobo. Khali lekha hobo on being mentioned matters are. Then finding similarity with item 25 matters were called for orders ja se 3 hobo. Yes, now 55 no.
Item 55, my lords, notice was issued to the legal heirs to appear. Mr. Pradhan, Mr.
In this case, I am appearing for the LRs of respondent number 1A, 1B, and 1C, my lord. For all the LRs
For all the LRs.
LRs of respondent number 1. And in the meantime, respondent number 3 has also died. Perhaps it is not within knowledge of my friend.
So you file a memo at least.
Respondent
There is
number
already appearance.
No, respondent number 3 died, there is no problem, my lord. It will not affect.
It is their party, my lord.
It is their party. Proforma party.
Proforma party.
It's not necessary. Only thing is that I am to file the consolidated cost item.
You have filed.
No, because that has not been permitted, my lord's instruction. Now that unless and until it is permitted, we cannot file, my lords. We prepared it, but we couldn't file.
Shall I file here or before the registry?
ଏଇଠି କରିଦିଅନ୍ତୁ ହାତରେ ଲେଖିକି
ଆଜ୍ଞା
ଏଇଠି ହାତରେ ଲେଖି ଦିଅନ୍ତୁ
cost item ଟା
ହଁ ନାଇଁ ଗୋଟେ ମେମୋ ନହେଲେ କରିଦିଅନ୍ତୁ ପିଲାଙ୍କୁ କୁହନ୍ତୁ ରେଡି କରିଦେବେ ଦେଇ ଦିଅନ୍ତୁ ଏଇଠି
ଆଜ୍ଞା ମୁଁ ଦେବି
ହଁ
Madam, I may be asking, shall I file here or before the registry, my lord? Bhakaladna.
in the pending of the writ application there is death of P1 pursuant to notice in substitution there is already appearance on behalf of the LRs through
R1.
counsel Shri Vidyadhar Pradhan. Yes, what is the matter?
Well,
OP
matter
number
is-
3
matter-
though died. It is stated OP number 3 is pro forma. There is
Not
no
proper.
necessity
He
of-
was the original owner. This property has come to the petitioners. So he is no more there. He has died once.
So there is no necessity of such
Any substitution.
substitution in respect of OP number 3.
Yes. This can be.
କରିବା, hearing କରିବା.
Yes, my lord. It will be disposed of within a minute, my lord. It's a OLR case. They said that they were the opposite part number 1 was the tenant. My lord, my humble contention in this case, my lord, kindly have a glance to the issues at page 45, my lord. That is at annexer, impugned order is at annexer.
Annexer 5.
Annexer 5 at for page 45, my lord.
Page 45.
My lord.
Issue number 1.
1. Whether the opposite party number 1 was duly noticed as per the direction of the Hon'Ble High Court. That was the issue number 1. Then they said that yes, it has been duly noticed because it was duly noticed under order type bulletin and paper publication was made. Then my lord, I'll have a glance to issue number 2 at page 47. Whether the order of this court is not accepted by not accepting Baklatnama of Sarat Chandra Mahapatra.
47.
Page 47. Issue number 2.
Yes.
Whether the order of the court is not accepting Baklatnama of Sarat Chandra Mahapatra and the resultant order setting the opposite party ex parte is legal and justified. Sarat Chandra Mahapatra claimed to be the power of attorney holder of the opposite party number 3, who was the owner of the property. That was not accepted and you was set ex parte. It is an ex parte order, my lords. My humble contention, parties may be given an opportunity, time may be fixed, let them appear. And
At the submission of respective counsels. There is no dispute in bar that proceeding by Annexer 5 has been decided ex parte for the settled position of law. Proceeding of nature of the proceeding involved should have been decided in contest of the parties. For undisputed fact remaining, decision is an outcome of ex parte order. This court is inclined to interfere in the impugned order. As a consequence, set aside the order dated 16/9/2000 in OLR case number 122/85, and as a consequence of further requirement of fresh disposal of the proceeding involved, matter is remitted back to the Revenue Officer Pipili for re-adjudication of the proceeding under section 15(1)D, vide OLR case 122/85. or there is already appearance of all contesting parties here, this court, while remitting the matter back to the opposite party number so and so, direct both the contesting parties to appear before the trial court, along with the copy of the order of this court on 19th of July or 24th? 24th.
Maybe it may be to August, my lord, because they may engage us there.
So 3rd of August,
My lord.
3rd of August, on receipt of copy of order and appearance of both the parties, the opposite party number shall do well in faithfully disposing the proceeding involved and in the involvement and participation of both the contesting parties.
Well, certificate copy they will produce, my lord. I will not produce certificate copy.
Petitioner,
Yes, my lord. My lord.
By either side will
You are the petitioner
by
there.
either side
By
any of the party.
Because they are the parties, my lord, so petitioner before there.
Yeah, 2001 रो ଗୋଟେ ସରିଗଲା.
Item 56.
56.
May I please, your lordship?
Who is for petitioner?
My lord, this is a very unfortunate case, my lord.
You are for petitioner?
I beg your, I am for the Odisha State Bar Council, my lord.
So,
I beg your lordship.
petitioner kiya ଅଛନ୍ତି?
Petitioner, nobody is appearing, my lord.
Therefore, let us dismiss the matter.
My lord, my humble prayer, my lord, your lordship may consider. Because I could not able to take any.
Let somebody place the case. There is nobody appearing for the petitioner.
Whatever your lordship.
Take up this.
Whatever your lordship is.
So dismiss for non-prosecution kariba. If the matter is restored, then I may enter into merit.
Okay.
Okay.
I'm grateful.
Yes, nobody is, there is death of the counsel appearing for the petitioner since long. Though there is set of counsel appearing for OP2, there is no representation on behalf of the petitioner in the process. This court unable to proceed with the matter and dismissing the writ petition for non-prosecution of the by the petitioner.
Item 55. Item 55 minutes. And friend is there. Please observe that without being influenced by Annex 5 minutes.
Okay, Sitra Khali Dhadi kar do. Fresh disposal shall not, the observation, if any, in the impugned order shall not have any influence.
Annex
5 shall have no influence in the fresh disposal of the matter.
Item 57.
May I please, madam? In this case, the petitioner is the president of Bharat Sevashram Sangh, madam.
Pardon?
The petitioner is the president of Bharat Sevashram.
Okay.
And one house has been allotted, MIC house has been allotted in his name, personal name. The only limited prayer is that house may be, at least permission may be granted to execute in the name of the ashram, Bharat Sevashram. And in pursuant to that.
And have you made any application to the authority?
Yes, made an annexure 2, my lord.
Annexure 2, then
Yes.
there is no outcome to that.
They have in annexure 3 at page 17, they have made that your prayer at page 18, my lord, they have made that your prayer at present time is not possible. But in the meantime, the latest development is, which I have made in my case, which is on the board of my lords. They have already started execution of lease proceeding, my lord. And in annexure 2 of that case, they have stated that as the writ petition is pending before my lord. So
prayer is twofold. One, the property allotted, MIG house allotted in favor of Swami, petition number 1 in the individual capacity. Now he wants the lease deed is to be executed in his favor. The lease deed to be executed, his processing fee, in the meantime, he has deposited the processing fee and other requirements.
Yes, subject to compliance of the statutory compliance.
Yes, that is why I have no objection to that. Second part of the prayer is, now he wants the property is to be transferred to the name of the ashram itself. So that unless.
For that he is to approach.
He has to approach. He
This
do the need
may
for
approach
that.
and you may give a lawful disposal to such
Yes,
request.
following the
If
principle.
it is a genuine request,
But compliance of the requirements is necessary.
Okay, all right. Consider the submission of the respective counsels. Requisition involves twofold request. One, executing the lease deed between the petitioner one and the development authority. Second prayer appears to be second prayer to read re nahi miscase re koruchondi.
Na second prayer ta read re achi transfer painga seta hei par na tha unless lease deed
prayer achi.
Se jo representation na dechu answer 2 re setre se
See, only prayer number produce relevant record prayer 1. Mandamus to grant lease deed within so execution of lease deed.
Lease deed ta se direct
in favor of the Sangha.
Sangha paper directly hei paribo na unless it is transferred to his name.
Okay, all right. Twofold. One, executing the lease deed in favor of petitioner one. At the same time, there is also request involved for transferring the property in the name of Sangha.
Yes.
There is fine landed counsel appearing for the petitioner in reference to the on the basis of instruction submits, there may not be any difficulty in executing the lease deed in favor of petitioner one, but for the purpose of
on compliance of the requirements. On compliance of the requirements.
Submission ta mu kohuchi. Okay, in compliance of the statutory requirements, but there is, however, resistance in transferring the property in the name of the Sangha in absence of any appropriate request and consideration of the competent authority thereby. Considering rival contentions of the parties, this court seems fine. There is no difficulty in executing the lease deed in favor of petitioner one. Let all out attempt be taken by development authority in executing the lease deed in favor of the petitioner one as a first step, but however subject to compliance of necessary requirements, statutory requirements, if any, being communicated to the petitioner by development authority within stipulated time. Let this action be completed within a period of 2 months from the date of communication of order. So for a second prayer is concerned, this court for finding there is no approach to the competent authority of the prayer number 2 as of now. It may be open to the petitioners to make necessary approach to the development authority for the decision at their end by putting an application at least within 3 months. Execution ta saru tapare karibe. Ago apanka right asu tapare apan transfer pai debe. Now within a period of 3 months. 1 month of the date of execution. In such event, the development authority is directed to give a lawful disposal to such request in the involvement of the petitioner. This observation and direction the read petition stand disposed.
Blessed.
Apan publication ta kai ete pachhere achi March re achi. Ora bada boi kar do na kai ki 2-4 mas ro.
नहीं एबे मैं जून जाइस मैं
अच्छा आपने जिक्शन करंतु. It's my suggestion.
Yes.
Consider karantu. There are a lot of decisions remaining unreported. Okay. You have your constraint because it is 100 pages or 102 pages, so you accommodate only 2 judgments or 3 judgments of each judge. Why don't you introduce this NOC, notes of cases? So that can cover at least 100 cases.
Yes.
Give 5 pages, 1 paragraph each. Then let the people search for the judgment, whole judgment. It is already available in net.
Once we update our subscription, then we will.
Taku ebe to June, July publication to start karantu. NOC ta.
I will take care.
Every publication gives NOC, and they don't find so much accommodation. So you can adopt that, and people get benefit of judgments.
Yes.
Small judgments are there, but not reported.
Yes.
Okay. Yes.
Item 58.
May I please your lordship?
58. Yes, Mr. Naik, what is this case?
This is regarding non-acceptance of the
2019 ro.
say
What is the
counter file
statute
kariba-
involved?
Lordships, they
Please be on mic.
Tahsildar is not accepting the rent, Lordship.
Tahsildar not accepting rent and the read petition is pending since 2019.
19, because the government has to file instruction. Till then, they have not filed.
Yes, 3 extra copies have been served on the state council. What is the development? ଏଥିରେ କଣ counter file ହବ କଣ ଆଦେଶ?
I would copy them.
There is a counter affidavit 2 and 3. What you have said?
ମତେ ଦେଇନାହାନ୍ତି copy. ସେ
There is already counter.
ନା ମତେ ଦେଇନାହାନ୍ତି copy.
Krishna is trying to mislead the court. No schedule of property has been mentioned in the prayer portion. Yes, sir. So you give a proper application to the authority. Yes, sir.
Lordship.
Add the submission of Sri Naik and Sri Ponda, counsel for respective parties, read petition in the following prayer. In response to the issuing notice and service of copy, OP number 2 and 3 have come forward to file counter affidavit indicating in para 3, specifically indicating in para 3 as follows. There is no dispute in the contention of the state opposite parties herein. As a consequence, this court find difficulty in issuing a writ of mandamus involving the request herein except in the disposal of the writ application permitting the petitioner to put up an appropriate application with property details to the Tahsildar involved. If such an application is made to the Tahsildar Cuttack, OP number 2, at least within a period of 2 weeks hence,
2 weeks time,
along with the copy of order, the Tahsildar
copy
OP
of
number
this
2
writ
shall
petition
do
also.
well in giving a lawful disposal to the same. It may also to be open to the petitioner along with the application to enclose document in support of his claim, if any.
They should not disturb me. They are not disturbing me. They
Is
should not.
there any interim order as of now?
No,
I say rent accept करना disturbance कौन होगा?
ସେ କେତେବେଳେ କେମିତି ତାଙ୍କ ସରକାରୀ କଥା ମୁଁ ଗୋଟେ
That's a
house
different
protection.
issue. But as it appears, you have already faced a OPL proceeding.
OPL because in this matter, Lordships, OGLS Act,
So
Lordship.
there exists some dispute. ଆପଣ enforcement case ରେ fine ବି ଦେଇଛନ୍ତି.
Fine ଦେଇଛୁ କିନ୍ତୁ
Okay, in the event petitioner still holds the property, let the petitioner not be disturbed. At least the Tahsildar takes a decision on his press application.
Lordship.
59 ଟା ଆଉ କୋଉ court କୁ ଯିବ ହେଲା since this court is not. CJ court mention ରେ କଣ mention କଲା ବେଳେ କହିଲେନି କି ମୁଁ ଶୁଣୁନି ଓକିଲଙ୍କୁ ବୋଲି ସେଠୁ ଏଠିକି ଆସିଲା କି So what is the other option available?
ଆଉ ଗୋଟେ ଡେଟ୍ କରିଦିଅନ୍ତୁ ସେ personal appearance.
Last order ରେ ଲେଖା ହେଇଛି to provide one more chance. Therefore, how many
Last chance.
chance you want now?
Last chance.
And one more chance ଲେଖା ହେଲା ଆଉ last କୁଆଡୁ ଆସିବ? The order says reach this matter on 7 July 2023 to afford one more opportunity to OP number 2. Order dated 30/6/23 reveals as follows. There is deliberate violation and non-attendance by OP number 2. This court is constrained to issue NBW as against OP number 2. Na kontu tara. OP number 2 no na kontu.
I'll give that. I'll collect it from the website and I'll give it.
Yes, sir. In course of day itself.
Just now.
So, ensuring, production, fixing the date of production of the OP number 2
Last chance ଆଉ ଗୋଟେ ଦିନ.
on 25th of July. ଆସିବେ ରାଷ୍ଟ୍ରପତି ସେଦିନ ଆସୁଛନ୍ତି, ବହୁତ ପୁଲିସ ଆସିବେ, ସେତେବେଳେ ତାଙ୍କୁ ଧରିକି ପଳେଇ ଆସିବେ।
Small prayer matters.
ଆଉ
3 ର address ଟା ଟିକେ ଭୁଲ ଅଛି, ମୁଁ ତାକୁ correction କରିକି notice opposite part number 3 ର address ଟା I may be permitted to correct here.
Okay, all right. The on oral submission, there is permission for correction of address of OP number 3
and to take notice.
Okay, based on correction in address of the OP number 3, requisites कौन करते separate रखते हैं requisites if already filed in respect of OP number 3 be issued forthwith.
Also, it cannot be. I am to file a press requisite because that I have given wrong address. I am to file press requisite.
Okay. Press requisites, if any, may also be filed by Monday.
Yes.
File. Yes, Baki 22 matters. Let me not hear any further new cases. The council man opaya karantu. I will not take up any big matter.
61 62 is a very small matter. 63 matter. 63.
Permitted to withdraw.
I am opposite party, my lord, because they have stayed the process of inter-ballot trial.
But hearing I can't undertake.
It's not a hearing, my lord. The last occasion, Violet said I will take half minute. And unfortunately, what is happening?
Right, I am fixing some matters to Friday. Today I have already disposed about 5-6 hearing matters.
But on Monday?
Friday केवल करूँची hearing करीबी.
Hearing नहीं है. Hearing
in any case, I am to hear both the sides and close the matter.
Because it's a case, simple point, whether the election petitioner, the person who has filed the election petition can be examined first or can be examined later. An application was filed, it was allowed by the trial court, but they have challenged that order. In between, my lord, 5 witnesses have been examined.
In election petition?
My lord. They have stayed it, my lord,
the
respondent please to direct it the year.
Respondent is asked to be reading first.
Yes, my lord.
Respondent is asked to read first.
Petitioner filed an application.
कितने number सेटा?
My lord, WPC number 5792.
5792. Item 63. I am for 63. 63 filed. This should be the only case to be heard. Yes. How case गुड़ा का सुनो? अन्य case गुड़ा की तो शुक्रवार listing करो ना. गोटे शुक्रवार गोटे को add करियो. जेती की शुक्रवार मोरा और रहिला.
I'm sorry, my lords, I'm making this statement, mentioning, my lords. Item 66, my lords. It's very urgent. I'm not asking for final disposal.
63.
66, my lords.
66.
I'll visit your lordship to take it up just for 2 minutes after my London.
No. How nine?
This is a case where lordship's order has been flouted pursuant to lordship giving specific direction. They have heard.
गोटे शुक्रवार रे गोटे केस आसीबो
एंट्री मॉडल ता से कहउचंते आमे कारण एंट्री मॉडल 26 तारिख पर गलानी तो आमे सुनिबो एंट्री मॉडल थाई कि ना
एंट्री मॉडल कंटेंट फाइल करंतु
the entire petitioner is under insolvency. They could not have proceeded.
File a content.
Entry model to continue at least entry model to continue. Item number 66. Entry model to continue.
Entry models are continuing. It will continue.
Item number 66. Entry model to continue.
सबूत रे जो मैटर रही गला देखा जीवो जो थरे एंट्री मॉडल अछि सब अलाउ करा जीवो कंटिन्यू.
I have Small prayer, my lord.
How small prayer bhi suna jivan.
No, only
Yes,
one,
Mr. Dhala.
one line, my lord. My lord.
Sorry, only one case, 63. Only 63. Sorry. Yes.
Begins 61 ta infructuous is that is my submission.
Uh-huh.
Serial number 61 has become infructuous, my lord.
Kota.
61, serial number 61.
61 infructuous hai gala.
Yes, your lordship.
Read petition has gone infructuous.
Yes, your lordship.
Memo file karandu.
Yes, I will file with
61
the
declared infructuous. Hala.
Thank you, sir.
Memo filed to this effect we kept on record. Mr. Ponda appears for the opposite party. Yes. Mr. Rao, how aaj ki suni
Next week, 64.
interim order sabutre extend hobo. My question.
Next week,
Next week. No, I am arranging in order of Fridays because I will be giving hearing opportunity to the councils only on Friday.
Correct. That's it.
Because in any case, I am undertaking some hearing in the fresh admission also.
Right.
So therefore, how much strain I can put?
I understand that.
Tape mo obvious bhi kharab hi jo. If I go on engaging myself till end. Mo future pe mu phuni ଆସନ୍
ସେ କହୁଛି apex court କୁ
ଆସିବ ଆସିବ ମୁଁ arrange କରିଦଉଛି ଗୋଟେ Friday ରେ ଏଥିରୁ ଗୋଟେ ପଶିବ.
Yes, ma'am. My order is 7/2/2023 at page 8. Annexure
Yes,
1.
order dated.
7/2/2023.
Yes, what is this order?
Starts from page 8, the relevant page is page 11.
This was an application for
Page 10 latter part. Then we have a glance to the order. The
letter order, yes.
The order arises out of the petition filed by the petitioner on dated 21/1/23. Order passed on 27/2 with a prayer to permit her to give evidence later. The petitioner submitted that she is a lady
You are for the return candidate.
I am for the return candidate.
You challenge this order.
My lord, I have challenged this order. What happened? The GP Act says that trial shall be conducted in accordance with the CRPC. In accordance with the CPC.
No, Mr. Dhala, this is not a proper order.
My lord,
In a election petition,
my lord,
it
by
is
the time
the responsibility of the election petitioner to begin first.
my lord, she was ill. My lord, an application was filed. Yes, an application was filed that has been duly considered, and two witnesses were examined. After the examination of the two witnesses.
Now, if she is ill.
No, my lord, she will be examined, my lord. After in between 5 witnesses have been examined. My lord, 9 documents have been exhibited.
Okay. 5 witnesses of the election petitioner.
Election petitioner, my lord.
Whether election petitioner has been examined or not.
My lord, they have stayed it. They got the order of stay in the month of February 2023. By the time this order was passed, 4 witnesses were examined.
Nothing. This is the wrong.
No.
Oh,
I have given.
Please take your seat. Yes. No, there is no running commentary possible. I am asking him a point.
Yes.
And he is answering, you intervene. Please take your seat. Please take your seat.
We could have been examined ourselves by this time because in between, my lord.
No. Who are the witnesses examined?
My lord, PW 1, 2, doctor, and the 9 documents have been exhibited on 24/2/2023. Morning court. My lord, they got the order here.
Whether return candidate, whether the defeated candidate is examined or not.
No, my lord, because of the stay order. And I raised this point before vacation.
No, because of stay order means this order has to be stayed.
This order was stayed by on 28/2/2023.
Absolutely. Thereafter, there is no possibility of recording evidence.
On 24/2 the ballot may kindly.
Now, you have to understand the difficulty, Mr. Dhala.
Ballot.
Unless the return candidate is examined.
Ballot may kindly see my counter, page 26.
What counter here?
Ballot.
It's a statutory proceeding.
My lord, the prayer, my lord was pleased to direct by which my lord and Fred has not mentioned in the body of the writ application, the WPC number 16843 of 2022, that to be disposed of within a period of 3 months by order dated 8/7/2022. I don't know why he has not mentioned that. But why not we say advocate for the petitioner is present or
You filed it as annexure A/1.
A/1, entire order sheet. Advocate for the petitioner is
So
present.
what do you want to support?
My lord, opposite party number 1, 2, 3 are present. Witnesses, namely Pranati Patnaik.
ठीक है, mic आगे रहो
My lord, witnesses, namely Pranati Patnaik, Nirbala Kumari Das. Page 26, order dated 24/2/2023.
Yes.
Advocate for the petitioner is present, learned and counsel for OP number 1, 2, and 3 are present. Witnesses, namely Pranati Patnaik, Nirmala Kumari Das, are present on behalf of the petitioner on recast of summons issued to them. They are examined as PW1 and 2, respectively, and cross-examined is deferred. Exhibit P1.
Just 1 minute, I am not finding that place. Order dated 4/1/23.
24/2/2023, madam.
24/2. That's
Page,
not in
page
26.
26, madam, of the counter.
24/2 is, you are placing internal page.
Pilot, internal.
There is running page already. 24/2 is page 36, your internal is 26.
Pilot.
Okay, that is running page 36.
Running page 36, pilot.
Yes, advocate for prisoner
Is present, learned and counsel for OP number 1, 2, 3 are present. Witnesses, namely Pranati Patnaik, Nirmala Kumari Das, are present on behalf of the petitioner on recast of summons issued to them. They are examined as PW1 and 2, respectively. 9 documents are marked for petitioners with objection. Witnesses, Dr. Sandeep Kumar Swami has prayed for adjournment. The prayer is allowed. At this, Lord and Counsel for the OP number 1 has filed a petition for filing the affidavit evidence by witnesses for the petitioner. Copy served on Lord and Counsel for the 27/2. My lord, the case is record is put up today. Lord and Counsel for the petitioner and OPs are present. The counsel for the petitioner has filed a petition seeking permission to replace the exhibit marked as original registers with the certified copy of the exhibits. Had the petition is allowed. The certified copies are attached to the exhibited documents. The original registers are returned so and so. Accordingly, on 28/2, my lord was pleased to pass the order of stay. So before vacation, I draw my lord's attention, but my lord said no, let it be taken up after vacation. So by this time, my lord petitioner. By this time, petitioner would have been examined because earlier, considering the prayer of the petitioner, my lord was pleased to pass an order on 8/7/2022. 8/7 that to dispose of the case within the period of 3 months. They are playing hide and seek because they know.
The broader question involved here is, can there be shifting of the examination of the election petitioner?
My lord,
beyond the examination of the opposite party, the elected candidate,
my lord,
you will be suffering. You will be suffering.
One thing, my lord, may dispose of this writ application, directing that the entire case will be completed within a period of 2 months.
That's right. But
okay.
But I will not approve this order.
No, my lord may say,
I'll interfere in this order and will say the proceeding will be concluded within 2 months.
My lord can
within 2 months.
My lord can refer this order
because this will create a new precedent. This is only Mr. Dhala.
My lord,
you are not conducting civil cases. This is possible where there is a partition suit and somebody respondent comes forward with a case that there is only a partition.
Status of plaintiff and defendant.
Only that has to be established and that may fail the suit.
My lord, I have got a decision on that also. Let me see this.
No, if it is an election case,
no, it's not.
Then it is wholly not applicable.
For that
wholly
reason,
not applicable.
For that reason,
you may go through that decision.
Well, I was not showing
must be on a partition suit.
My lord, referring the earlier order, which was passed in the year 2022, directing.
I had the submission of respective counsel. The writ petition involves a challenge to the impugned order dated 7/2/23 particularly the latter part in the impugned order, thereby directing examination of the returned candidate after the examination of the respondent therein. Considering the rival contentions of the parties, this court find there is no such process available in an election dispute and settled position of law unless the election petitioner witnesses are completely closed. There can't be commencement of evidence of counsel for respondent. Order impugned if approved.
We are the election petitioners there. She is the returning
It
candidate.
will create a bad precedent. Thus, while interfering in the order dated, latter order dated 7/2/23, setting aside the same and keeping in view that there is urgent need of disposal of the election dispute, this court, while directing the parties to appear before the trial court along with the election tribunal, along with the order of this court on 12th of July, also direct the and taking into account that there has been already examination of at least 5 number of witnesses. 5 number of witnesses.
Cross examination was record.
There should be closure of the entire proceeding at least within a period of 2 months from the date of appearance of the parties.
4 witnesses instead of 5, 4 witnesses have been examined. 4 witnesses.
4. All right. It like there, since there is substantial progress in the examination of witness card, there are 5 lekhan. Yes.
Pardon,
The evidence of these witnesses will remain as it is. This evidence will be of these witnesses will remain. They will cross-examine the witnesses.
On 28 June 2023, stay was granted. I have filed a petition that stay was granted. Morning court.
आपको तो allow हेलानी.
हम cross examination करने हमको scope भी देंगे.
This evidence.
If any
cross examination
party is deprived of cross examination on an application being filed to avoid future complication on an application being filed by such in such requirement, the trial court shall do well in providing opportunity of cross examination.
But it could be completed within 2 months.
12th को fix appearance. Within 2 months of appearance, case will be closed.
In accordance
and
with law.
Both the parties are directed not to take time.
Yes, this also restricts unnecessary adjournment.
Adjournment नहीं कि in accordance with law. कहना सिटी law for किच करना है.
आया election petitioner आपनो.
Evidence affidavit भी देंगे नहीं.
आपनो.
Evidence affidavit file करना.
से return candidate.
आगे.
Return candidate. तेणु obvious तांका reason रही जेते गड़ी जीवो सेते से अमल करी दे.
Tell. तांकर जो जीवाटा tell. तेणु से time लूचे नहीं. और tell.
Evidence affidavit तो उन्नांती.
जान. Thank you.